Mr. Barr? All right. Welcome to tonight's City Council meeting. The public can attend tonight's meeting in person at the George DeFiero City and County Buildings Council Chambers, located at 1 Tacoma Drive, or watch live on Channel 8 and through live streaming on Broomfield's website. The public may also participate in public comment either in person or by calling 855-695-3744 and pressing *3 to be placed in the queue. Please note that if you're calling in for public comment and would like to speak on more than one agenda item, you'll need to press *3 each time to be placed back in the queue for comment. Public comment will be limited to 90 minutes total per item. The first 1 through 15 participants in the queue have 3 minutes to speak. The next 16 through 25 participants in the queue have 2 minutes to speak. And if time remains, the next 26 plus participants in the queue have 1.5 minutes to speak. Again, if joining virtually for public comment, the number is 855-695-3744 and press *3 to be placed in the queue. Screeners will ask callers for their first and last name, neighborhood, and the agenda item the caller would like to comment on. Please call several minutes before the agenda item and press *3 to ensure you're in the queue for comments. If joining in person, we'll ask you to come to the podium and state your name and neighborhood for the record. The City Council regular meeting is called to order. Will the clerk please call the roll?
Anderson. Here. Cohen.
Here.
Hinkle. Here. Dzerzowski.
Here.
Leslie. Here. Slim.
Here.
Lindstedt.
Here.
Marshall.
Here.
Schaff.
Here.
Ford.
Here.
Quorum is present. Will everyone please rise and join me for the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
In order to keep order for tonight's meeting, I ask council members to limit their comments to 5 minutes. Abby will be assisting us with the timekeeping. Additionally, please remember council's rules of order regarding conduct. When possible, council member comments and communications should be limited to 5 minutes per individual per item. If council members are given an opportunity to speak for a second time on an item, they should limit their comments to 2 minutes. We will plan on a 10-minute break at approximately 8 p.m. We will begin with council's review and approval of this evening's agenda. Council may add or remove items from the consent agenda, or council may revise the order of business for the meeting. Does any member of the council have any comments or questions regarding this evening's agenda? Mayor Pro Tem?
Working on it.
Oh, okay. We'll pause for a moment. It's okay.
I was gonna motion that we put item 14A, the legislative updates, on the consent agenda tonight.
All right, are there any objections to this agenda being approved as modified? Seeing none, the agenda is approved. Thank you, Mayor Pro Tem. There are no petitions or communications this evening. We will move to public comment next. This is an opportunity for the public to comment on matters other than the items already listed on the agenda. As mentioned earlier, the public may comment both in person or via phone. If you're joining on the phone and want to be placed in the queue for comment, please call 855-695-3744 and press *3. If you're joining in person, please line up behind the podium. Public comments will be limited to the time limit outlined earlier. Anyone in person? Not seeing any, so we'll go online, and we do have a general caller, Mr. Robert Bueller. You have 3 minutes.
Thank you. Here is what the Public Health Department won't tell us. As of Friday, December 10th, there are nearly 1 million adverse events to the COVID-19 vaccine reported on VAERS. There are 10,025 deaths reported from the COVID vaccine. There are 8,032 reports of myocarditis. For those of you who aren't familiar with VAERS, it's the Vaccine Adverse Event Reporting System. That data can be searched through cdc.gov. That is the government's own data. The world's top cardiologists are warning the public of the dangers of vaccine-induced myocarditis, even in children. There's also an alarming number of athletes dropping dead from cardiac-related issues. Prior to the unveiling of the COVID-19 vaccine, these events were nearly unheard of, especially in children. Now it seems to be commonplace. Certain media outlets are already trying to cover the tracks for the pharmaceutical corporations, claiming that these heart-related illnesses are from a newly invented condition known as post-pandemic stress disorder. So we have the media playing aloof and the government running a protection racket. Mask mandates and proof of vaccination make no sense from a medical standpoint, and they're even harmful. True health is not achieved through these methods, and many Coloradans know that, as we are among the healthiest states in America. Even Governor Polis changed his tune regarding mask mandates. In a recent interview with CPR, he stated the emergency is over. Public health officials don't get to tell people what to wear. That's not their job. Councilmember Cohen attempted to discredit the facts I presented last session. I realize honesty is an uncommon characteristic these days, and I want to make clear that I have no interest in propagating falsities. The factual science is here, and if our local public health department had anything to do with demonizing early therapies that have proven effective for COVID-19 in order to railroad the Broomfield public into mass vaccination, we deserve an apology and an explanation. Councilmember Marsh Holston wanted to echo the dangers of misinformation. I couldn't agree more. And it turns out that the misinformation is coming from top-tier health agencies who continuously trample on liberty under the guise of protecting health. I'm disheartened that the corruption of big pharma and the incompetence of big government has trickled down to Broomfield. I seriously question the credibility of our health department. I question the city council's allegiance to American liberty and justice for all. Most of all, I question everybody's loyalty to human rights. Thank you.
Thank you. I'm not seeing any other callers, and I don't see any online, so we're moving on to council's community and event updates. Does any member of council have an update this evening? Councilmember Shah?
Thank you, Mayor. So I just wanted to say that I got my booster this last weekend at the Broomfield Rec Center, and kudos to the Broomfield staff and the state for running such a great vaccination flag. It was run very seamlessly. It was a little chilly out there, but I think we made do and continue to move people on. So I was very happy to be part of that. The other thing I wanted to update council on is just yesterday we had a meeting with the Rocky Mountain Metropolitan Airport Community Noise Roundtable. We talked about one of the big things that we talked about was Lafayette becoming part of the Noise Roundtable. They are not a current member, but they will be presenting to their council about becoming part of that. They presented to us in order to get our agreement to allow them to be a part of that. We also talked about the need for a new facilitator. We had a facilitator this last year, but we need another one as that contract ran out. We will also need a consultant to help us with the ingress-egress assessment for the airport. With those two pieces, it is going to raise, most likely, it is going to raise our dues for that community noise roundtable. So hopefully in this next month, we'll be working with staff to look at what that's going to be. So just wanted to update my colleagues.
Thank you. Any other council member updates? All right, thank you. We'll move on. Council's consideration of the consent agenda is next. Following the clerk's reading of consent agenda items 7A through 7E and 14A, we will ask for public comment. Will the clerk please read agenda items 7A through 7E and 14A by title?
7A, resolution number 2021-168, authorizing the naming of the publicly owned parks in Palisade Park North Development. 7B, resolution number 2021-200, certifying levies upon all taxable property within the city and county of Broomfield for tax year 2021. 7C, resolution 2021-165, authorizing and approving an agreement by between the city and county of Broomfield and DTJ Designs Inc. to provide Consulting services for the update of the open space, parks, recreation, and trails master plan. 7D, resolution number 2021-164, approving the Colorado opiate settlement memorandum of understanding. 7E, ordinance number 2170, amending certain sections of chapter 5-42 of the Broomfield Municipal Code related to regulating marijuana establishments within the city and county of Broomfield. 14A, 2022 legislative update and council's review of proposed 2022 legislative principles and policy statement.
Thank you. We'll now proceed with public comments. Does any member of the public have comments on these agenda items? Starting with in person, if there's anyone who'd like to be heard, please come to the podium, state your name and neighborhood for the record. Seeing none, I don't see any online either, so does any member of council have comments on these agenda items? Yes. Oh, thank you, Councilmember Anderson.
I do have one question for the legislative update, which was put on the consent agenda. In the link to the policy statements, I just want to note this, and I think we can change in the future, but there is CC4CA's policy statement is not included with the other policy statements. I just want to note that.
Ms. Brewer, I'm going to come down.
Thank you.
Mayor, Returning Council, thank you for that question, Councilmember Anderson. The reason for that is we're a little bit ahead this year than we were in the past. The policy statements for a lot of our membership organizations had been approved when we published the memo, so we will make sure that those links get added as they get solidified, as well as for excuse me, as well as for CML, CCAT, and those as they move through the membership organizations.
You're welcome. Thank you. Is that all? Any other comments or questions on the agenda? Okay. Is there a motion that the recommendations contained in the staff reports for agenda items 7A through 7E and 14A be approved? Okay, Councilmember Marshall.
So moved.
Second, Councilmember Schaaf.
Second.
Is there any discussion? Councilmember Lim is joining us virtually, therefore we will use a roll call vote tonight. Will the clerk please call the roll?
Anderson? Yes. Cohen?
Yes.
Wolf?
Yes.
Jaworski?
Yes.
Leslie?
Yes.
Lim?
yes,
Lindsay?
Yes.
Marshall?
Yes.
Schaaf?
Yes.
Ward?
Yes.
That passes unanimously. There is no business before the Board of Social Services, Board of Health, or Broomfield Housing Authority this evening. The first item under council business this evening is council's consideration of proposed resolution number 2021-206, approving a conclusion of operations agreement with Extraction Oil and Gas. Council has a copy of the agenda memorandum, which I'll ask our staff to summarize.
Thank you, Mayor. Good evening. I want to start this conversation by honoring and valuing the community members that have sent in comments with regards to this conclusion agreement, and those that have continued over the last 3 years to struggle with those impacts. Your comments and concerns do not fall on deaf ears now, or will they in the future? I do want to, the agreement, Nancy and I, Ms. Rogers and I are going to go through a very brief PowerPoint that gives the highlights of the agreement. This agreement was negotiated, and there's been a lot of communication that they reached out to us. They did not. This was initiated by staff seeking to do something that they have been, and they being Extraction prior to Civitas, completely adamantly opposed to, which is opening the operators agreement. The two pieces that we focused on was securing the number of a reduction of wells and ensuring that in 12/31/21, that when the conclusion for them to vacate Broomfield was done with some certainty. Again, there's a lot of, as is always the case, with any highly emotional issue, there are statements that are made that are opinion-based and not fact-based, but they turn into being fact-based. So again, a couple of highlights. Civitas is not extraction. I understand that our mistrust, rightly so and rightly earned, for the years that have passed since the operators agreement. The individuals that Ms. Rogers and I have been working with are Civitas, not extraction. In fact, the extraction contractors, which is not unusual, for particularly legal counsel to remain involved after a merger has taken place, especially on a merger and acquisition of this size regarding this amount of funds. Our conversations and communications have not been with extraction. We understand that the umbrella organization continues to have to carry the mistrust. And that's fair and warranted, and they agree. That said, having those two pieces of the operators agreement reopened, there's a lot of communication that they weren't planning on drilling the 19 wells anyway. And our comment to that was, are you sure? So when we negotiated the agreement, solidifying that was one of the very key components while we were moving forward. There's also a lot of communication that expediting, or accelerating their operations to finish by December has created overlap and thus additional impacts. It's the reduction of the 19 wells spread out through those pads that has promoted and provided them to accelerate that schedule. The schedule itself has not driven multiple operations on those pads. The continued presence beyond 2031, 22 in the current operation agreement, so that's another one of a lot of the comments that are out is we're rolling something back to 2017. We're not rolling anything back. The 2017 operators agreement has been, continues to be, and will be in force as the guiding document for all operations on each one of those pads. This agreement does not modify that. What the agreement does is it takes a certainty of 5, they are not exceptions. Right now, our next challenge will be the definition between spudding and drilling. We've all anticipated that. Ms. Rogers is prepared for that. We've had ongoing conversations with Civitas to that effect. The reason that we wanted to open the operators agreement to that effect was we wanted to be able to say with some certainty that there are only 5 exceptions that they could stay. Where it's written right now, it is in perpetuity. Once those wells are spudded, which they all are, when it comes to 2031, 22, the opportunity for them to continue once they're spudded continues in perpetuity. The contractors at extraction, I want to be really conscientious of kind of the legal parameters. But they were not advising Civitas to open the operators agreement at all, particularly with these 2 sections. It is not lost on them that the inclusions of this language is not something that old extraction would have welcomed then, and it continues to be or now. That said, next slide, please. And I want to say too, I feel compelled just from a note of we're not pitching the community nor council, nor are we selling, whether it be this agreement or any agreement in the future. We are putting together a package that we think to be better than status quo. It's as simple as that. We will, as staff always does, rally behind this community and this council with whatever decision is made and the outcome to be as successful as possible as we move forward. Next slide. I'm saying that to myself because I have it up on my screen. I apologize. So the terms of the agreement, as we already stated, 84 to 65 with certainty. Plugging and abandoning the wells that are not part of the 65. Nancy will go over the terms of the existing contract. There's also a lot of communication about the 19th well on the Livingston pad and accessing the Acme pad. In order to do that, so Ms. Gilbert and Ms. Rogers have sent out communique through the oil and gas communication as well as to council indicating that that is not, nor could it be. It's not technically possible in B. It would require an additional permit back through COGCC, which would fall under 181. Extraction, part of Ms. Rogers' ability to include in that the contract, there was some, I don't want to say misunderstanding, but certainly clarity that needed to be required. That any subsequent legislation that was applicable statewide would apply to extraction and any other oil and gas operator in the state of Colorado. If it is a statewide law, it applies. Nancy solidified that. That was not a new addition. That's always been how it is. Again, if it's a statewide application. Any new permits, any new operations, any new drilling would require the COGCC to issue a new permit under the new guidelines and regulations, including anything that occurs at the Acme pad. Next slide, please. Sorry, I keep saying that to myself. Nancy, I'm going to ask you to go through particularly the ones that had a distinction in the new operators agreement, and then the amendment that's applicable to both parties. And if we could clarify the conversation and comments about what we're giving up, which we'll wait till the conclusion of the conversation. So, Ms. Rogers, would you like to?
Sure, thank you. And I want to echo Ms. Hoffman's comment about we do really read and took into account your emails and the comments that you put forward, considered the arguments that were made. I'm in a weird position where I can't share my analysis necessarily with the public because that's attorney-client privilege. I have shared it with counsel. So what I'm going to share with you today are sort of the facts, really comparing the conclusion of operations agreement with the current operator agreement. And I apologize if I'm not able to address every question, but I have taken your arguments and tried to respond to counsel with my analysis of those. So as Ms. Hoffman mentioned, we have the reduction from 84 to 65. That is absolute. There is no exception to that. It is 84 to 65, period. The second term is plugging and abandoning wells by a set deadline. Right now, that deadline really isn't in our operator's agreement. There's a list of wells they must plug and abandon, and they're almost done doing that. They have a few more, and then the 19 will be included on that list. Then going to, this slide that Jake has up right now. So this commencement and production, as Jen mentioned, the current operator agreement says drilling must commence by a date certain, and that's December 31st, 2022. And we have asserted that was always intended to mean true drilling, as lay people understand it, in the ground working a well. As Ms. Hoffman mentioned, extraction has made it known that they believe a spudded well is drilled. So we knew that was going to be our next fight, that they might still be here and not in production at the end of December of next year. So it was really important for us to try to negotiate a must. So this conclusion of operation agreement says you must be in commencement of production by December 31st, 2022. That's where we started the negotiations, and as many of you have noted in your comments, and rightly so, there are 5 exceptions now. This was hotly negotiated, and this is where we landed. The 5 exceptions are listed there. Supply chain issues, price per barrel drops, issues with getting a frac fleet, and other issues that are listed on that slide. Whether or not this is better or worse than the current operation agreement, I think is one of the challenges that our council needs to consider tonight. I think having that date certain does avoid an argument on spudding versus drilling later, if we were to have that argument, but it does add in 5 exceptions that aren't in the agreement right now. Next slide, Jake. Thanks. One sort of smaller provision that we were able to get, which we think staff believes is really helpful, is getting a monthly schedule from extraction the first day of every month. We actually don't have that right now in the current operating agreement. And then the not return provision. This was another thing that we went with absolutes from the beginning. You shall not return to Broomfield was where we started. And where we landed was a provision that many of you have noticed is not that solid, right? Not that certain. It gives some provisions, but it says operator further agrees not to perform operations. That's where we start. Provided, and then it lists these exceptions. And we understand, and many of you have pointed out that those exceptions could be, abused, loopholes utilized. I agree that is correct, but this is the term we were able to get in exchange for you're telling us you really want to be in and out. So that's on the not returning for further operations, and then no maintenance or facilities operations from 7 p.m. to 7 a.m. Maintenance right now is allowed at any time. Next slide, Jake. Thanks. I'm gonna do the first and last one. Well, I'm gonna do the last one. Notice by email is a perfunctory change that it's just gonna be easier for us if we send extraction notices of breaches, which we do. The city agrees not to enact future regulations. I want to make it clear that we have in the current operators agreement a future regulations provision. It says we will not pass future regulations unless it's applicable to all industrial and commercial operations. This is a similar type of future regulation provision. It shifts it though from saying what you can do. You can pass something that's general and applicable to all to say you will not pass anything that's targeted to oil and gas. So it is a little more specific. This is what extraction wanted from Broomfield. This is the consideration that they wanted on the table. But I want to make it clear that we're in a situation right now where Broomfield is not permitted to pass future regulations that aren't applicable to all commercial or industrial operations. That's why we've been in noise litigation. And the applicable code is 2017. In the conclusion of operations agreement, applicable code is defined as the municipal code as stated in the operators agreement. And in the operator agreement right now, the applicable code is the 2017 code, except where it's stated as amended, which is often in the operator's agreement. So we are actually right now in many regards bound to the 2017 code. That ties in with the future regulations provision. So that's sort of a general summary of trying to compare the two agreements. Jennifer, did I hit on everything you wanted me to cover? Was there anything else?
No, that's the end of the,
Does that conclude?
it does, Mayor, thank you.
Thank you. We will now proceed with public comment. A friendly reminder, as previously outlined, the public comment will be limited to 90 minutes total per item. The first 1 through 15 participants have 3 minutes to speak. The next 16 through 25 have 2 minutes. And if time remains, the next 26 plus participants have 1.5 minutes to speak. Does any member of the public have comments on this agenda item? We will start with in-person public comment. If there's anyone who would like to be heard, please come to the podium and state your name and neighborhood for the record. Please limit your comments to 3 minutes.
Kristen Logan, excuse me, from the Anthem Highlands neighborhood. I watched a meeting, April 29th. It was a special meeting called by this council. In that meeting, Nancy Rogers specifically answered questions that she's not answering tonight. In that meeting, she asked questions about sidetracking operations in future operations. And she made it very clear that there were certain things Extraction could not come back and do without new permits. It was also very clear that the local 2,000-foot setback would apply to new permits that were requested. I'm hearing tonight that SB 181 would be applied, and there is a 2,000-foot setback at a state level. However, there's also an exemption of that 2,000-foot setback if a local municipality gives permission to waive it. With that being said, removing our 2,000-foot setbacks locally, in my opinion, leaves us unprotected. I don't think this is a good choice. And I don't think it's a good choice with this particular new operator or any operator, if it was a completely new operator trying to apply for an exemption. Some other thoughts that I initially had in listening to this is the future regulations clause. We are in a situation where an oil and gas company wants something taken out of an agreement. So hearing the words that we don't have the power to use this agreement anyways makes me question, well, then why would they take it out? I mean, what is the point then? Why would they sacrifice something that they could make money on if this is meaningless? I mean, it just doesn't make sense. 1 + 1 is not equaling 2. Moving on to that, future regulations clause. This is power that we give to our elected representatives, and trying to trade away the power that we invest in you to an oil and gas company just doesn't seem to make sense. I would also like to touch upon the idea of the 2,000-foot setbacks, how things change. Back in December, when I first moved here, there was a meeting with Extraction Oil and Gas about having 26 wells drilled in our neighborhood. We all attended this meeting, and we were told they would be great partners, they'd be in and out in under 6 months. I walked out of that meeting thinking, wow, this isn't ideal, but 6 months has been a lot of time. The great December deal happened right around the same time of the year when no one's paying attention. Everyone's off on break, kids are getting out of school, it's finals. Next thing we know, we come back, 144 wells are on the table. The great December deal. Seemed to have cemented something that was only 26 wells to 144. To this day, I've never been told how or why that happened. The only thing that changed was the renegotiated agreement. Please take care when signing agreements. Please take care of things that are being said and not said. And please take care to keep our local protections in place. You work too hard for them to give them away. Thank you. Thank you.
Hello, my name is Mackenzie Carriman. I live in the Anthem Highlands community. I do not agree that Extraction and Civitas are different entities. I believe that long ago, this company came to us and lied bold-facedly to us. I believe all the executives from Extraction are still present in Civitas. I don't trust them with a single thing. So I'm asking this council to vote no on this agreement. During the 5 years I've been engaged in these discussions about oil and gas activity in Broomfield, I've learned a lot of things, but there's 2 lessons that I particularly would bet my life on. Lesson number 1 is that Extraction, Civitas used interchangeably is not to be trusted, period, end of sentence. They have a vivid history of deceiving the public and the council. They've duped all of you before, don't let them do it again. They've created what is one of the worst, most lopsided contracts known to man, and the city signed this. That is also called the MOU. We all know this well, and it's told us over and over again how this MOU has tied the hands of the city council. If this MOU is already doing this, why would we sign an agreement that gives an exemption for paragraph 15 of our MOU? Paragraph 15 is the only paragraph in this MOU that gives the city any power. I'm going to go ahead and read the future regulations clause. I'm sure all of you have read this, but this is in the current MOU. This is what Extraction is trying to take away from us. Future regulations. The city reserves the right in the future to enact and apply prospectively regulations that are general in nature and that are applicable to all commercial and industrial operations in the city, even though such regulations may be more or less stringent than than the standards applicable to the well sites by virtue of this agreement, provided that such regulations are not preempted by the law. Nothing in this agreement affects the city's ability in the future to impose a transportation impact fee on the operator to the extent that such fees are applicable to all commercial transportation originating or terminating in the city. This agreement erases this clause, totally erases it. It would erase any noise ordinance opportunities. It would erase any ability to learn lessons from the experiences. It would erase the ability to create protected measures for residents in the future as it applies to Civitas. In fact, if interpreted broadly, this part of this agreement could prohibit Broomfield from regulating any of Civitas's operations in the future into infinity. So it's written broadly enough where we could never again apply anything to Civitas. We're only now starting to understand the level of benzene exposures that our children are being exposed to and we are being exposed to, among other toxic and harmful chemicals. There's so much we don't know. There's so much we don't know. And to take this power away from Broomfield when we have so much that we don't know is harmful and unnecessary. Please vote no on this. There's so much to be gained. Thank you.
Thank you.
Good evening. My name is John Barn. I live in Anthem Ranch. I have a couple of questions about this deal. Is there a time limit or a date necessary for the agreement to be done? Do we have time to do more discussion on this? My second question, I'll give you a couple and you can answer it. The second question would be, is this involve just extraction and not Crestone Peak? Can Crestone drill in Broomfield after this agreement? Third question is, will refracking be limited after the date? Is that still possible 5 years from now for extraction to refract these wells? And I think that's about it. Thanks. You may want to, if you can answer some of those questions.
Yes, that's okay with me. Would you like to answer those, Manager?
Between the two of us, we certainly will. And it's good to see you and thanks for those questions. We appreciate it. I'm going to have Nancy answer the refracking possibilities subsequent under and this is all under the current agreement and not part of the conclusion of operations. John, what was your first question?
Is there a deadline to sign this agreement?
Part and parcel. So these are so we've been in conversations with them for since late summer, and at some point you just you have to say this is as good as it gets, and again. Having staff recommend to go in one direction and having the community in another direction just continues to be a perilous path. So this is the final agreement, and opening those two pieces of the operators agreement. This is what they want in return in order to make that happen. So it's continued to be staff from oil and gas to the lawyer's office. That is it perfect? No. Is it close to perfect? No. Is it fraught with loopholes? It is. And going on record to say that we are not representing that we would like to have modified the entire 2017 operators agreement. However, that said, we remain in the position that this is better than what we have right now. So this is the best and final offer. Nancy, do you want to speak to? And then as far as Crestone goes, again, any drilling, a lot of the focus right now is on Acme Pad, and us communicating and working with the COGCC under 181. One of the pieces that this community and this council has been so actively participating in big wins is that now neighbors communities that are surrounding impacted oil and gas operations have the opportunity to weigh in, and not only weigh in and have a voice at the table, but actually be at the table. So we feel that the data that we have been collecting, not only from noise, but air quality monitoring, will certainly influence future decisions that are going to be made specifically regarding Crestone's. Nancy hasn't elbowed me for any legal stuff yet, so I'm assuming that what I'm saying is continuing to be okay. So yes, we will come out swinging at the COGCC with regard to the ACME path, but this time, instead of indicating that we think there will be impacts and we just don't like it, we actually come equipped with data that is significant, compelling, and influential. And Nancy, do you want to take the last one, please?
And I'll give up my time and let her finish.
Oh, thank you, John. So your question was, can they come back and refrac in 5 years? So the way the conclusion of operation agreement landed at the end of intense negotiations on this point, because we started with thou shalt not come back and refrac. The operator of Extraction agrees not to perform operation on its well after they go into commencement of production. And remember, commencement of production is supposed to start by commencement of production by December 31st, 2022. However, we have these provided as clauses, and I know we've talked about this with council, provided that a contract doesn't require them to come back and do the type of maintenance that would require a drilling rig or a frac spread. I will tell you, we did negotiate those very intensely, and the intent was that they are not returning to frac unless they absolutely have to, that it's supposed to be in production by the end of December 2022. Now, I say that acknowledging what Jennifer pointed out about the history between Broomfield and Extraction and the lack of trust and what this provision might mean given that history.
Thank you, Ms. Rogers. Next.
Hi, I'm Anne Marie Cleary, and I'm here to urge you all to vote no. I've been in this position behind this mic for far too long. We have dealt with understanding agreement after agreement failed. People are sick now. People are suffering. Spikes are happening now. I sit here and listen to hear you say, yeah, we had to give up that. When do we stop giving up? We stop now. We have put all of you in there because we have all sat here and we still sit here breathing the poison. And we say, this is the best we can do. Well, now we have a whole nother company, a conglomerate getting bigger and bigger. This is not the best we can do. Giving up future protections that we don't even know right now that we're going to need. We don't know what's going to happen to the people when you add more wells. We know what's happening now, but we don't know what's going to happen. And we're going to sign it away. We even possibly sign it away. It's just not acceptable. In this moment in time, and what we know, it's up to every single one of you to stop the madness now. Our health and safety is on the line, and we shouldn't be bartering it away. I commend the staff for trying, but this is oil and gas here. This is a company with endless amount of funding to do what they want, when they want, if in this case they want. And it's just not okay. I ask each and every one of you that we all worked our asses off worked our butts off to get you all in here because we believe in this moment in time. This moment in time is every single one of yours. And it's ours, not just for Broomfield, but for Colorado, the Denver metro area. Jared Polis is where we started all this, is now our governor. We need to stand up right now, and we need to not sacrifice or barter away our protections. Thank you.
Thank you. Next.
Good evening, Mayor, Mayor Pro Tem, Council, and staff. Lindsay Mario from Wildgrass. Okay, I have to go a little bit rogue here because a lot of new things came up and it sounds like a lot of things have already been addressed. So usually I'm a little bit more prepared, but I need to address a couple things I've heard tonight. I I am here to speak in opposition of this proposed conclusion of operations agreement. Before I get into my reasons why, I do want to give a massively sincere thank you to the staff that tried very hard to do something positive for the city of Broomfield and for the residents. I appreciate it. Thank you. I know it took a long time and a lot of hours, and when you're dealing with oil and gas, it's difficult to come out ahead as, with a win. My opposition to this agreement primarily lies with Extraction and the track record they have in teaching us that we cannot trust them. I understand this is Civitas, however, the ambiguous language, the loopholes, the tremendous asks of Broomfield with giving what feels like next to nothing back shows they are the same old Extraction. From an impacted resident perspective, I understand a reduction of well count feels significant and looks significant on paper. Health impacts have been, it's not going to change our health impacts. Reducing the wells from 84 to 65, it doesn't change anything in terms of what's already going to happen to us and what has happened to us. One thing I really that came to my mind was the refracking, and I'm really curious if, sorry, I have all these new notes. Leases were looked at, if contracts were looked at, if Broomfield did its due diligence to see if this clause is already in some contracts that Broomfield has. If Broomfield has requested to look at leases of extractions that may require them to come back and refract, or have them legally affirm that their contracts do not have that. Future regulations, it seems like people think we don't have anything, but we don't know what we don't know. And I would really hate for our council down the road to say we'd love to be able to do something, but the council of 2021 tied our hands. That's what the council of 2017 did. Don't be the council of 2017, learn from them. Don't tie a future council's hands because we don't know what we don't know. Gosh, I have so much more to say. Extraction is extraction. They're asking for something because they want something. They don't give up wells. They don't give up profits. They just don't. They have shown us who they are, and I really don't feel that they're changing this now that they're Civitas. So if they're, just be careful. I urge you to vote no, please. It's not worth the risk for the future. Thank you.
Thank you. Is there anyone else in person who would like to comment on this item? Well, then we'll go online, and we do have one caller. Kathy, you have 3 minutes.
I'm here.
Yes.
I'm here. Can you hear me?
Yes, we can.
Okay, so I wanted to request that you not vote to approve 206. It's a very slippery slope. In fact, it looks like a disaster. So I've been following this for years and been involved, and we were promised all kinds of things along the years. There was a risk assessment that was supposed to be paid for by Extraction. Broomfield paid for it. It was kind of basically rotten. Other things that are in place right now, we've got the noise monitors, but there's a lot of problems with them working correctly because it's too noisy for them to work correctly. We've got public health that won't be transparent with us, but they give everybody complaint fatigue. We've got a lack of transparency on that. And then we've got the AQM that is supposed to be correctly measuring benzene levels coming out of these pads, and they are not. And I want to know if it's okay with you guys, these exposures of benzene that we're getting, and is it okay with you that they're not really measuring the peak maximum? So I did send some emails out to council members, an analogy where you're going to measure the temperature of your water at your faucet. So you turn your hot water on and you stick your hand in there and you start waiting for it to warm up. And then it slowly starts to warm up. And then you measure it when it's starting to warm up. And you take the temperature, and that's your one and only shot until you get your next trigger canister in place. So you never get the maximum temperature of the water coming out of that. And that's an analogy to what this AQM is doing. And the other problem with the AQM is I think they've spent over $1.5 million, and yeah, go ahead and fact check me on that. So the response from Ajax about why why they open up the valve to trigger the canister to basically suck in air into the SUMA canister for 1 minute leads me to believe this is, it's like academia, and City of Broomfield collects taxpayer money, and this is being paid for with taxpayer money, not academia money. So it's not clear why this is so experimental and why we're not getting accurate measures of the benzene levels coming off these pads. But that's included in the write-up that I sent in. Anyways, I want to know if it's okay with you guys, with the benzene levels that we're being exposed to, knowing that they might even be twice as high as what they're being measured, or maybe even 3 times, because you're on the shoulder of a peak. You're not at the peak maximum concentration. And if there's any way you could evaluate the role of public health in this project and how they deal with us and how they communicate information to us for our health and safety, that would be appreciated. Thank you. Bye.
Thank you. Let's see, I see someone else being screened in, an inbound caller. But they're not yet. So, do we wait a sec? Thanks for your patience.
And Mayor, if I may say with regards to the prior call, those questions and comments are probably better suited for staff responses when we move through the 3rd item, which is the air quality monitoring quarterly update.
Good point. We do have that following. So Ms. Bogart, if you're listening, there'll be an opportunity to comment on and ask questions at the next agenda item for the oil and gas update. So we do have Pam Wannock screen, and you have 3 minutes. Pam?
Hi, this is Pam Wannock, and I just now found out about this again, where now we've got another company that's taking over Extraction. And I just wanted to talk a little bit about kind of the Mickey Mouse with this. So Extraction goes into bankruptcy, goes through solvency court, and now Cevatis wants them, but they want them with different terms. It's as if Cevatis did not read the other terms that they were already involved in. So that's concerning to me, and also guaranteeing them that we're going to work with you if oil drops below $55 a barrel. How many people in this room have your investments that you're guaranteed to make a profit? So this, to me, this is just a shell game. I can tell you as a resident that's out here directly involved with Northwest A and B pads, that this has been a nightmare for us. I'm constantly listening to the clanking of the pipes during the drill phase, and right now they are doing the coiling, which is when blowback is most likely to occur. But to sit out here and to deal with this it's nerve-wracking at best. I just couldn't even explain to you how difficult it is to live with this day and night. One of the comments made by staff was that Extraction didn't know that drilling and spudding were the same thing. And they're not the same thing. I hope they don't think it's the same thing. If they did, then they shouldn't even be out there to begin with. So I am asking this council to really reconsider adopting this. Cevatis knows what they're walking into, and they don't need to have any changes to this MOU. Thank you.
Thank you. Doesn't look like we have any other further comments. So questions from council are next. Members should limit themselves to questions during this portion. The time to introduce amendments and state positions for or against this item is later. Are there any questions from council? Councilmember Shah?
Thank you, Mayor. So I just have 2 questions. We've discussed this in executive session, and so hopefully these questions can be answered. One of them has to do with the future regulations. So this is, as staff said, this is one of those areas which was covered within the operator agreement, and yet they reiterate this within this conclusion agreement. How does this, the stronger language that is in this conclusion agreement affect Broomfield's ability to legislate to protect health and safety of Broomfield residents?
It limits Broomfield's ability to pass a targeted ordinance. So if the only reason for the passage of the ordinance is to regulate extractions operations, oil and gas operations, it would be void as to extraction. This is the arguments that were made in the noise litigation case, and you can see it in all the publicly filed litigation documents in all those cases, that under the current future regulations provision, Extraction had argued that this was specific and targeted legislation against extraction operations. It wasn't general to all industrial and commercial operators. So there's an argument to be made that it's the same side of a coin, or it's a different side of the same coin, excuse me, to use that saying. Can it be exploited, which is a concern that was raised by residents? Yes, potentially. This was Extraction's goal, because I'm walking a thin line here. After the operator agreement was signed in 2017, with the future regulations provision, council passed the noise ordinance and tried to, and made it general and applied it to everyone and enforced it on Extraction's operations. Seeing that Extraction said, this is what we want in this agreement. We want something that confirms and reiterates you will not pass targeted legislation against us. So I hope that answers your question. I have one more piece, Councilmember Schaaf. Extraction said, if you want to enforce against us, do it under the operator agreement or under state regulation, not your own code.
The other question I have is the voluntary dismissal without prejudice. Can you talk a little bit more about what that means and what that would mean for Broomfield as well as Extraction?
Right. We have two remaining cases involving Extraction. In both cases, Extraction is the plaintiff and Broomfield is the defendant. To dismiss a case means it'll go away, right? It ends the case. Now you can either dismiss a case with prejudice, which ends the case. That means you can no longer bring those claims again, or without prejudice, which means potentially those claims can survive to be asserted another day. Another hotly negotiated item, Extraction agreed to dismiss the cases, but would only do so without prejudice, which means for Broomfield, if Extraction decided they could attempt to reassert those cases, file a new lawsuit and bring those claims. The easy example is if you have a car accident. Councilmember Schaaf and I are in a car accident. I sue him, but then I dismiss the case without prejudice. I then sue him again in another year for the same car accident. That claim survives.
Just to be clear, I was not the one driving.
That remains to be seen.
Can you give us, tell us what those two cases are that are out there that they would dismiss without prejudice?
Yes, there's a federal case, which is a constitutional and contract claims case that Extraction filed in federal court. And there's a state case that Extraction filed. It's called a Rule 106 appeal, where they, if you remember in the noise ordinance, there was a process to ask for a variance for the noise ordinance. They actually claimed that Broomfield improperly denied them that variance. So there's the state case on the former noise ordinance, and then the federal case that is still survived.
Thank you so much. That's all I have, Mayor.
Thank you. We had a late caller get screened in, so I'm going to, with council's permission, go back to the phones and give the floor to Jennifer Bellis. You have 3 minutes.
Hi, can you hear me?
Yes.
Okay, great. Thank you. Sorry, I am driving back to Broomfield from New Mexico, so I am on a freeway. I will make my comments very short. We have some very, very bright people that we have elected to public office who very closely followed this issue. So I appreciate their questioning of this document. I am just calling in to urge a no vote. We have been forever locked into a deal that the 2017 council provided us with, much to our chagrin. And I see a lot of loopholes in this and don't see the upside. So I trust some of those folks that have been elected to continue to ask good questions like I just heard Devin doing. I'm going to hop off the phone, but I appreciate you all. I appreciate your work and I appreciate your questioning of this document. Definitely suggesting and hoping for a no vote this evening. Thank you.
Thank you. We'll go now to Councilmember Anderson.
Thank you, and I appreciate all staff's work. I just want to make sure that, that we recognize the great amount of effort that went into this agreement. I appreciate our many residents who have been emailing in and showing up to make public comments, and I'm sure we've all had many phone conversations with residents who are very concerned about this. So I want to I just want to note, and I'll ask my questions here, that this conversation that we're having tonight just enforces the many issues with the 2017 operating agreement. Well, thanks. It was so often stated, back in 2017 and prior that without such an agreement, the extraction could drill an unlimited number of wells. And we now know that they didn't even need the 84 wells, that they only really need 65, is how this is appearing to turn out. I do have questions about the noise and emissions. Most of those will be for the council agenda item down from here. But I think it's important to recognize that what I heard most from constituents is, why are we moving forward this agreement that precludes us from doing future regulations when we haven't even addressed the noise and emissions that continue day after day after day? This happened at Livingston, it's happening at the Northwest Pads, and we have, we've filed noise complaints and we're working on that. We are just now gathering data. We are leading in the nation on air quality monitoring, and we're now capturing what we've been. It's taken us some time to get to this point where we find out, hey, we need trigger canisters, and now we're getting the samples, and now we're getting the information that shows the benzene spikes, and we're working on trying to stay in the plume. And so how can we give up the ability to enact future regulations before we solve these two basic problems? I guess my question here is, beyond that, because we don't probably have an answer to that question, is in staff negotiations, did you have any conversations about these two main issues that are just always looming? And what was Extraction's response?
We have conversations with them multiple times every day about the impacts, about the noise, about the emissions. While we were navigating this agreement, so the first part of that, so the first part of what you said, Councilmember Anderson, is really important. And that is, and that will get back to the air quality monitoring when we have the quarterly report. This technology is brand new. The noise technology is brand new. The air quality monitoring technology is brand new. And as we adapt, so for Broomfield, the programs and initiatives that we have in place and have had in place, unfortunately, were not in place when the drilling originally started. So from a baseline perspective, so what we're gathering right now, is it comprehensive enough to influence CDPHE to a certain degree that would overlook the current federal guidelines? The answer is no. Again, from CDPHE's perspective and from CDPHE's perspective, we have a meeting set up with CDPHE, gathering questions where they will come once again and provide input and background and data about how information is collected and what they can do with it. So I think, so what does Extraction say about the noise? They, again, from staffs and our inspectors, again, we have a team of 10 people that do nothing but oil and gas in this community. And part of the, and I don't say that to say, geez, aren't we great? Are we going above and beyond? I don't say it for that. I say it to emphasize the information that we're gathering and the knowledge base that we're getting is unlike any other community information and data that's being gathered thus far. part of the impact for them under the operators agreement is we can only enforce the existing operators agreement. And so when we say benzene spike, we don't have a baseline for benzene. We have snapshots, and that's the best that we have right now with those canisters. We'll talk more about that during the quarterly update. So their response is, Nancy and I just sent them the follow-up on the noise violation to be moving through the process because their mitigation isn't working. So with regards to this agreement, no, it wasn't part of that agreement. And again, from staff's perspective, what we said we wouldn't do would be targeted to extraction, would be targeted to an oil and gas operator that would not be applicable to any other industry, which is already in the 2017 operators agreement.
Okay, thank you. And I want to talk a little about the future regulation clause. And when the concern about this agreement locks us into the 2017 Broomfield Municipal Code, which is prior to 2000 setbacks, it's you know it's in these whereas clauses. Those whereas clauses could even if it's not certain which ones apply, and we start talking about something in the future that we don't know, and the last thing we want is for the same residents who have already been through, whether it's at the Livingston pad, the Northwest pads, or the interchange pads, is to find out that, oh, surprise, we're actually going to sidetrack. We don't even know all these operations that could potentially occur. I mean, the sidetrack that could go to another section. I guess that's a separate question, is could they, as a current agreement, the spacing unit currently is bordered, I bought my house on the north side. So not quite, it's just sort of trying the very edge of Anthem Highlands and just up to the very edge of Anthem Ranch. The current spacing unit does not include the majority of the Anthem area. And if they were to add on that spacing unit, would they do that under this current contract, or is this like null and void, it has to be complete separate contract?
Complete separate contract. They would have to reapply to COGCC. Same thing, Councilmember Anderson, as the Acme pad. When the application had already been submitted by Crestone, and the only reason I bring up the Acme pad is the process would in fact be the same. So any state regulations subsequent to Senate Bill 181 would be applicable to any new operations, whether it be setback or the 2A permitting. Our rules and regs would not preclude the application statewide to oil and gas operators under any state legislation.
Except that if they could in any way tag on something to this operator agreement, the state requirements for 2,000 foot setbacks have an off ramp, and I could completely see the COGCC noting that you already have wellheads there, and that they're already, whatever's done, and then if our 2017 municipal code didn't apply, then we wouldn't have our 2,000 foot setback. So I'm just curious, could they ever foreseeably under this contract add on another spacing unit, in which case I don't think we have a clear answer on that.
So I'm gonna have Nancy answer that question, because maybe she can be a little clearer than I was.
No. If they have something outside of the 84 wells and the spacing units that we're aware of right now, they don't have a contract for that. So it would need a new contract. And they would need to apply for new permits. And any new permits would be covered by new COGCC regulations. Now, whether the COGCC allows them some leeway, that's on the COGCC. And are you talking at all about our residential setback too? The residential setback, the 2,000 foot residential setback absolutely applies, because that applies to developers. That applies to people building residential houses. They're the ones that aren't allowed to build within 2,000 feet of wells. So that actually isn't targeting extraction and extractions operation. That developer, Rogers Development LLC, would not be able to build within 2,000 feet of an existing well. Residential, yeah. So we have two 2,000-foot setbacks. We have the state one, right? And then our own 2001, which definitely will apply to new development.
Under the current MOU, I'm sorry, I don't want to speak out of turn, but I don't understand what you're saying. Is
You
it
need to
possible
come
to-
to the podium. I'll give you the floor.
Thank you, I appreciate it. Thank you, I appreciate it. Did you just say that they would need a new contract if they wanted to apply for anything further? Is that correct? So by new contract, you need a new MOU?
They can't drill into another spacing unit under this operator agreement. They're limited. So if they wanted to, they would have to enter into a new agreement with the city and county.
So in this spacing unit, they can come back and drill and do other operations under this MOU. They would still have to apply for new permits with the state.
It depends, and there was a question about what can they come back to do, I believe John had asked, under the current agreement. You know, they can, and Councilmember Lim has asked this on multiple occasions, what does maintenance look like? Because under the current agreement, it allows them to return to do maintenance, and whether that maintenance requires a new permit is dependent on the type of maintenance that it is.
And do you recall the April 29th meeting where former Mayor Pat Quinn was asking specific questions without sidetracking?
I do.
And do you remember saying that the 2,000-foot setback, our local one, would have to apply to any new permits? Has that changed? Or would that change under this agreement?
New permits, no.
If we signed this new agreement, if they had to get new permits to sidetrack in this spacing unit, would the 2,000-foot setback still apply?
New permits, new applications, no, yes.
Our local 2,000-foot setback would still apply?
To anything new, yes.
But they aren't going into a different formation, they're staying in this spacing unit.
Mayor and Council, I think we're gonna have to get back to
Okay,
council with
Thank you.
this response, because
I actually was curious about the answer.
right, but I think we're talking apples and oranges a little bit, so if we can take a minute and so we just have a minute and we'll come back to this as you think.
Yeah, sure. Does that mean you want me to read that for a minute? or-
No, I think the one for
Oh, okay. Just a minute.
I want to clarify too, while we're thinking, so there's our 2,000-foot setback that is now applicable to all future residential development. This agreement, whether it's the existing MOU or it's the new conclusion agreement, would not impact that. If you are a developer and you want to develop in the city and county of Broomfield, you have to be 2,000 feet set back from oil and gas development. And I think this is what Nancy meant by apples and oranges. So that's the bucket of apples. There isn't anything that's going to preclude that 2,000-foot setback for any new development in the city and county of Broomfield with regards to residential housing. The other piece is, on that existing pad that already has a spacing application, I think the question, just for clarification, if there's any modification to that spacing unit with regards to the number of wells on that spacing unit that has been permitted by the COGCC, arbitrarily, they cannot, any operator, and in this circumstances, it's extraction. They cannot modify in addition to or accessing additional resources off of that pad without a new COGCC permit. So the spacing application as it looks right now is locked in. This agreement will not impact that. Existing agreements will not impact that. So again, if there's modifications to a spacing unit subsequent to having a Form 2A permit that has been approved by COGCC, additional wells on any pad would require this process being resubmitted to COGCC. Anything new, to Ms. Rogers' point, anything new that would occur, 181 would be applicable.
Sorry, we're gonna go back to Councilmember Anderson. Were you finished with your question?
Oh, no, okay, so I want to be clear though, we also have Broomfield has a 2,000-foot setback, from homes to oil and gas wells, so we have both. So the concern here that I'm hearing from residents is that if we, I mean, we can, continue this, maybe others have questions on this too, but if we put into this agreement, that's a 2017 Broomfield Municipal Code, and whatever it is that we don't know that happens in the future, we've written in stone that we're going to go by the 2017 operator agreement before Broomfield enacted its 2,000-foot setbacks from wells to from existing homes to both ways. And that you could potentially have residents living 1,320 feet away from future operations when they should be more than at least 2,000 feet from the edge of the well site and not 1,320 feet from the well head to the home. So I'll leave it at that. It is a concern. I don't think we're going to solve it here though. More investigation to that. But my other question it is a question of one of the emails we received, regarding if Broomfield proceeds with this agreement, are we giving up the ability to protect the health and safety of our residents? It cited some case law and talked about police powers. And you question that, like we're getting conflicted here that if we're saying we won't do future regulations, we know there's issues, are we getting ourselves into a predicament? I think is a question. I don't know if you can answer that. But I know we've heard in the past that the police powers, doesn't allow us to just go up and shut them down, but we continue to collect this body of evidence, including the health impacts, and starting to correlate that to cancer samples that show elevated emissions, whether or not they exceed some certain threshold when the state's still collecting data, doesn't have the toxicology data, no the chemicals. It just feels like there's a lot we don't know here. And so that is of concern to me. I don't know if staff wants to respond to that, and that's my final question.
Thank you.
Councilmember Anderson, on the police powers, the police powers here are talking about the legislative powers of this body to pass everything from traffic to stuff like oil and gas regulations. I'm going to refer you back to an attorney-client privilege email that talked about contracting away police powers. That is an issue, but I can't go into the analysis in public. Thank you.
All right, good. Thank you. Next is Mayor Pro Tem Jezierski.
Thank you. I'm gonna just have a couple of questions. I think we've beaten some of these things already up to a pulp. Can I go back to the future regulations? That seems to be the crux of everyone's concerns there. And it's my understanding that the MOU, was written in a way that says that we reserved our right to enact generally applicable regulations. So we've been through this in lawsuits, and as long as it's our position, as long as the lawsuit is applicable to all industries or all types of companies, we can enact it, or we can't enact still something that is directed towards extraction or any other industry. I think that's just a general principle. So the new proposed agreement sort of twisted, I guess, just sort of flips it around, like you said, the same side of a different side of something. I don't know what that analogy is, and I'm going to go away from that. But anyways, I read it over a little bit. It says that we would be limited from enacting any future regulation solely in response to or targeting operations, oil and gas operations, basically. So my reading is that it still allows us to enact general regulations, all right? Okay, so I mean, it sounds like, I know you said this, but I just want to make sure this is clear that, and I guess I'll ask a question, what are we giving up then? Because that seems to be the real sort of crux of this, it seems to be what Civitas wanted in the agreement. It seems that's the regulation that primarily that the residents are concerned about. So what are we giving up? It seems like beforehand, we were able to enact general regulations, but we couldn't enact anything specific. If we agree to this, it sounds like we still wouldn't be able to enact anything specific, but we would still be able to enact stuff that is general in nature. So where is the difference? Is it semantics? Is it perception? I mean, is there a difference?
So on the chart, Mayor Pro Tem Jezierski, Again, that's why the chart that Nancy had done with what the issues are, what the points are, where we are in the existing agreement, and what in our, so again, it is perception, and it is, it's opinion. And so, again, kind of the outline questions regarding COCC applicability of state regulations. Again, I don't know how we can say it more clear than no, it doesn't apply. But it remains out there to be a question. So again, from our opinion, and it just really, it seems like it's really setting staff up to be in contradiction to our community. And I love this community. I am a resident here, and that is not something I want. And there is no deal worth doing that and continuing to do that, period. What are we giving up? We're giving up the ability to have targeted legislation.
Although we never had that ability in the first place.
So that's I mean, again, somehow it's the giving up, right? Or the rolling back to 2017 ordinance. We're not rolling back anything. It's the 2017 operators agreement that applied then, it applies now, it will apply in the future.
If you look at the noise ordinance that was passed, the whereas clauses are specific about oil and gas. And that's what extraction is saying. Like, you passed this law because of us. That's what they wanted to try to avoid. So yes, the law was still general, but they said you still targeted us. So that is, so it is a little bit more narrow, because even if it's general, it applies to everybody. If the reason that Broomfield's putting it into place, if all the whereas clauses, if this debate is all about oil and gas, that'll be a target.
Okay, so we'd be able to pass something, but we'd have to make sure it is still very general. We'd have to leave out, as you mentioned, any mention of oil and gas operations in the whereas clauses or anything else in the regulation. But if there was something that council wanted to pass that would be generally applicable to the entire community, we'd be able to still do that. And if it happened to apply to extraction, it would be enforceable.
Yes, I would agree with that.
Okay. I am interested in hearing your response if you have one on the 2000 setbacks. My overall, I was confused by that, and I was, I guess my only overall arching question on that is just, is there any, this is where I'm sort of hearing from the community, is there any possible way that is being waived? You know, there's any possible way that a Civitas or someone can put wells that are new wells that are closer than 2,000 feet?
The key word there is new wells. For us, for Broomfield, a new well would have our new regulations apply. Even if they were able to try to wedge it into an existing well or tie it to the same pad that's going, the state would require a new permit. So the state 2,000 feet would apply. So it is, they cannot drill into the spacing unit without getting a new spacing order. They need to apply for a Form 5, and sidetracking is also not allowed without permission from the COGCC. And the new regulations apply to all those processes. So when you're talking about a new well and new activity, the 2,000 foot would apply, whether it's ours or state.
And then what does new wells mean? I guess that's the crux of the question, right?
I would say any that are not part of the 84. We know exactly where the 84 wells are right now, right? They're all spudded. I believe they're all spudded right now. Yeah, we know exactly where they are. So it's something that is not one of the 84.
Okay. And then if we had this new agreement, it would be anything that's not part of the reduced number. Is that correct?
Right, that's correct.
Okay. All right. And I guess I don't know if you're able to answer my final question, but I'm going to throw it out there anyways. I totally understand the skepticism that we're hearing from the residents. I think there's really good reason that they have the skepticism. Been a lot of shady dealings that's no other way to put it that have taken place over the last few years. And it sounds like what I'm hearing tonight is kind of you're sort of stick with the devil you know, as opposed to the devil you don't know. And that's kind of, I don't know if that's the right way to go. I team thumbs up, but I mean, that may not be the best thing to do. I mean, it certainly is maybe the safe thing from the standpoint that you're not giving anything else, but you also might be maybe giving up some good things. And I think we are giving up a lot of good things. So that's something to think about. You're shaking your heads and maybe not, but, and I guess that's the overall question I have, is that, and I think this is where the skepticism from the community is coming from is, why does Civitas want this? If it seems like to me that we're not giving up hardly anything, and we are gaining things. And I think that's clear. Whether they would drum or not, we are gaining the reduction of will. We're gaining a deadline. We're gaining the dismissal of 2 lawsuits. So I think that's big. And I forget some of the other benefits as well. So if there's nothing really in it for Civitas, why? Is this PR? Is it something? Why? If you can't, I get it if you can't answer that, but I think that's.
I absolutely can, but while I do, there's kind of like the black ops covert, some type of something that is occurring because they're not giving up a huge amount. So there must be something that is in this agreement that Nancy and I, Mike Foote, and a whole host of other attorneys didn't see or haven't seen. Again, the conversations were from reaching out to the CEO of Civitas. Even conversations as recently as today, some of these folks that remain on contract, remaining from extraction, they will not be sad at all with a no vote. That is one of the reasons that it took the amount of time that it took was because they have remained steadfast that this operator's agreement should not be reopened under any circumstances at any time, and they continued to carry that line. From Civitas's perspective, I mean, again, they don't do the media engine. I mean, if we can all remember, the oil and gas well in our open space with the sun setting behind it. Were we all horrified? Does it continue to be a picture in our mind? Absolutely, it does. So the residuals, there is no deal enough to overcome the residual bad feelings. There just isn't. And again, so tonight, what this for them having some certainty that they weren't going to have to be fighting any additional one-offs on the noise ordinance that we've already lost. And the applications of another one, it takes them off of what their basic daily operations essentially. So, I mean, again, they're not giving, they don't feel like they're giving anything up. If they were the ones originally here initiating the operator's agreement, all of those things would probably be in there. So again, from the bottom line perspective, Ms. Rogers and I felt that having some certainty was worth not initiating another noise ordinance that's already been litigated.
All right, moving on. Next is Councilmember Lim.
Thank you. I had a follow-up question to the scenario that we were discussing about sidetracking. So I can follow the possibility that the sequence of events for sidetracking into under Anthem Ranch would be combining the Lowell North spacing unit, which extraction already holds, with the Lowell South spacing unit, and that the COGCC would control that. I also understand that the staff said that sidetracking requires a permit and that would be controlled by the COGCC. Then the question becomes, does Broomfield have a voice in protesting such requests or procedures at the COGCC? It's my understanding that the operator agreement ties our hands that we are not allowed to protest anything that extraction does regarding these pads at the COGCC. So in the scenario presented, the COGCC would proceed with these combination spacing sidetracking permits without our voice in the conversation. Is that correct?
Councilmember Lim, that is correct. There is a provision in the current operator agreement where Broomfield agreed not to protest or request a hearing related to extractions operations at the COGCC.
Okay, so then, who knows what would happen there. Okay, and my other question is a follow-up to what Ms. Ilario asked. In section E, she asked if extraction provided any indication of how many mineral leases they currently have that would allow them the exception to refrac Livingston. It's based on the contract obligation and the mineral leases that would force the operator to continue production. So her question was, did extraction provide any indication of how many such mineral leases currently exist?
Right. No, we don't know how many leases they have, but I think there's more to talk about related to Livingston. We have an indication that they are done at Livingston.
Councilmember Lim, and that first question is and anytime that you present, somebody says, oh, that's such a good question, and sometimes it's patronizing. That's a really good question on that first one. And that is, again, another perfect example of agreements that were made in that original MOU that all of us choke on frequently, and that's one of them. That said, Nancy, if you could clarify and walk us back a little bit on the memo that you had done with regards to Councilmember Anderson and Councilmember Lynn's question with regards to the sidetracking, under what circumstance? So again, although we're precluded from existing operations on those pads from going to the COGCC, if they wanted to sidetrack, if they wanted to add any additional, it gets back to Ms. Logan's question. If they wanted to do anything additional on those pads, including sidetracking, does it follow under the existing MOU, or would it be, and I look like I'm stumping you because I thought we had the answer for that.
You're not, I know where you're going.
So let me finish with my thought. Councilmember Lim, if I may. Because I think this is the direction that you were going. So there's a difference between COGCC and the application of Senate Bill 181 with any new permits or movement on any one of our wells. The question is, and I feel like I'm a lawyer and you're in the defense chair, but does that fall under a new permit that COGCC? So in other words, can we argue, could we go down to Councilmember Lim's question to the COGCC like we will on the Acme pad and say, hell no, and here's why, would we be precluded under the MOU for having any additional modifications to those well pads, including sidebar?
I'm gonna answer this in two ways, and I'm gonna be slightly obtuse. One is to say we have participated in COGCC proceedings when it's about operations that are outside of this agreement, outside of what's allowed by this agreement. So I'll put that first point out there. The second one, I'm gonna read the entire provision in the whole one, so you can hear what will be said. And then I'm gonna have to keep it there as far as could we actually do that? Because I do think that's confidential legal strategy. The city agrees that it shall not protest, request a hearing, oppose, or object in any forum to any permits, applications, or similarly related approvals related to the operator's oil and gas operations subject to this agreement. So that last prepositional phrase would be a key phrase for us. But we have participated in proceedings involving oil extraction when they were not subject to this agreement. That's about as far as I can go. Now, oh, sorry.
So the clarification would be, if on the operating pads right now, the existing operations that fall under the spacing unit that includes the 84 wells, that in the spacing agreement, it calls out each one of those wells. If there was, for the COGCC, for sidetracking, which would then be, and I think it was Councilmember Ward said, what is sidetracking? Some of the conversations have been, can you access a different pad, which would be the Acme pad, not owned by Extraction, but owned by a subsidiary that's now under Civitas? Would it be possible for Extraction to access the Acme pad, work in conjunction with Crestone in order to access the resources from the existing pad? The answer is no. They would have to go back to the COGCC. Well, first they'd have to go through a whole host of different operators, but from a technical perspective, that would require additional approval from COGCC. Subsequent to 181, any additional activities with regards to oil and gas in the state of Colorado would be subject to 181. It would fall out of that existing MOU where we could, in fact, say we object, and here's why we object. Same thing that we're going to do on the Acme pad. I'm sorry, Ms. Rogers, what was your other point?
That was it on that piece. And I think Councilmember Lim, you were asking if we were aware of any of the lease agreements for Livingston, and we're not. We don't know what lease agreements exist for Livingston. And I believe you also asked a question of if those lease agreements under this conclusion agreement would allow them to come back and refrac. Was that the second part of your question?
Yes.
Yeah, because of the provided as provision. Yes, and that is one of the risks of the provided as provisions, that we don't know what those lease agreements say and what they would require. An important note, though, under the current operators agreement, maintenance is still allowed, whether it's required by a contract or not. And they can come back and do maintenance. Now, what is defined as maintenance is still up in the air. So we're sort of in a poor situation currently as well.
Okay. My last question, does it broaden the time frame for drilling beyond the operator agreement? Because Section E has these exceptions. So these exceptions about the mineral leases, conditions forcing the operator to continue production were not in the operator agreement, which said that they would not commence drilling after 12/31/22. Now we're looking at a conclusion agreement where they added to what Attorney Rogers admitted was not what we wanted. They added these conditions where they can refrac because of mineral lease clauses. Does Section E open us up to, do these clauses negate the operator agreement even, that they can't commence drilling after 12/31/22? Hopefully that question is clear.
It is, and it's another really good question, and we've spent a tremendous amount of time with Civitas on just on that. And so again, what we wanted to have in there was the wells have to be in completion. So right now, the open-ended language is that, and again, that's and some of the residents earlier, the definition of spudded and drilled. So those wells, all of the wells will have been drilled. They may not be in completion, which again is a different phase of the operations. We felt that having the language in that piece that said, the only reason that you would still be here, and if they're not completed, the only reason you would be here is if those 5 circumstances, and I think Mr. Foote spoke to this, that and his comment was, this agreement is better than what you have, and those 5 pieces, whether they're considered to be exceptions or not, still have, the possibility exists that those 5 may exist, but it wouldn't be any different than the language that we have right now about being drilled. So the question would be, how long after they're drilled can you do future operations based on those 5 pieces? I mean, that's really the question. So in other words, Councilor Moon, does it put us in a worse position than we're in right now?
I think that's a judgment call for council to make as they go for this agreement. It does have some concerns about it, but I think it's a better position, and I'll tell you why. Because under the current operator agreement, it says operators shall not be permitted to commence drilling at a well site later than December 31st, 2022. And granted, no exceptions to that. That's a hard deadline. You can't commence drilling. We have the issue of drilling versus spudding, but they could start drilling on December 31st, 2022, be in completion for however long it takes, and not be in production until months down the line. This agreement says you must be in production by December 31st, 2022. Granted, though, it does have those exceptions, which can extend that deadline. So I think, I don't know if that helps answer the question. I think they both have concerns as far as timeline for when we will get into production and have fracking be done.
All right. Councilmember Lund, can you wrap up?
That's it. Thank you.
Okay, thank you. Councilmember Leslie?
Thank you, Mayor. And again, staff, I want to compliment you on your initiative, your effort to try to get something done. Clearly, you've been on this for the last 4 or 5 months. So my question is, do we have to approve this tonight? Or can we have some additional time, as you've had to take in order to negotiate this agreement, so we better understand? I'm hearing so many soft answers, not that you can't help it, because of the complexity of this kind of agreement, not this individual agreement, but this kind of agreement with all of its subtle and legal ramifications and your own constraint that there's some things you just can't talk about in public. In a way, John Vaughn, I think, was asking that same question, and I'm not sure that was answered that way, and maybe I'm interpreting it a little differently, but let me go back to his question. Do we have to approve this tonight?
It becomes, from a Civitas perspective, from a CEO, and the other folks that are sitting around the table, save the extraction legal. I think it becomes more difficult for them to continue to have this be an open-ended agreement.
I understand. However, the residents, which is a larger plurality of people we're talking about here, have so many questions that I think deserve to be answered in the best way possible. And I just think, given the complexity and subtleties of this, it's so very difficult to do this in one night. And therefore, I'm less concerned about whether the CEO of Civitas would like to see this behind them or not. I'm more concerned about us, and can we continue to take more time to fully assess in a more deliberate way, if you will, than trying to rush it through in one evening.
So, thank you. Thank you for your thoughtfulness. And I want to make it really clear, I'm not looking out for Civitas. So when he makes those comments and it's kind of giggling in the audience that I am, that is, my point is, it makes it more difficult for the CEO of Civitas to keep the deal on the table because of extractions legal saying, this is not a good deal for us. This is not wise for you to open this operator's agreement. That's my only point. So again, will there ever come, I think the question, Councilmember Leslie, is, will there ever come enough answers to these questions given the ambiguity and loopholes? Will we be able to tighten that up? No. Will it ever come to a point to where our community that has been so tremendously impacted emotionally, physically, come to the place to where any agreement other than status quo is something that they would support? My guess is, over the plethora of questions that we've answered legally and otherwise, the answer is no. That said, from a council perspective, the same thing would apply. So if you vote the agreement down, then there's nothing to preclude us to continue to have these kind of conversations.
Okay. My challenge is wanting not to lose the advantages that may be inherent in this agreement. You all work very hard to try to get something, and I understand negotiations is not a one-way engagement. It takes two parties to try to come up with something, and I think you all have worked very hard to do that. At the same time, you started this journey with a huge deficit, and that huge deficit, you inferred many times tonight, is a lack of trust. Just clearly evident that there is a serious lack of trust. And what I'm suggesting is that we might be able to build greater trust with some more deliberate engagement and time, even just among ourselves, than I'm capable of doing, tonight. Given all I've heard, not just tonight, but from all the engagements, conversations, phone calls, emails, et cetera, come through. I don't want to lose the good things that are here. But I'm fearful that if we try to rush this thing tonight, and I use the word rush only in the context again of how long it's taking you all to negotiate this, and to your credit, and I know personally how you've struggled with this to try to get this done. And I compliment your persistence on that. So I don't want to give it all up because I still don't fully appreciate the benefit versus what's already there. Because we've talked a lot tonight about, well, this is already there. It's already in the 2017 agreement. Doesn't add anything. This new agreement doesn't really add anything on that side of it. And in addition, there are some other things that, yeah, there's some ambiguity, some risk. We really haven't spent as much time as I'd like to on what is really in it that benefits everybody, particularly around the health and the noise issues that continue to dominate, the worries. And because people are suffering, because people's families are experiencing the effects of these gases and the noise and stuff, this is serious stuff. This is not just a typical contract. This is more personal. And so I'm, if you will, advocating that we spend a little bit more time to try to get it done tonight. So, thank you.
If I can just add a quick point, this is a two-party agreement, so at any time Civitas could withdraw and not give the option to vote. The other thing is we have a couple of court deadlines coming up, both our pending cases have status conferences coming up in the next couple of weeks. Not that the court wouldn't entertain more time, but that is some of the things driving the presentation tonight as well.
Thank you.
Thank you. Councilmember Cullen?
Thank you. I just have a couple of quick follow-ups for clarification for me. If I could ask Bruce's question another way. Like when you get a price estimate, it expires in 30 days. There's nothing in the contract that says this will expire in 30 days, right?
That's correct.
So the only risk we take in not acting tonight is Civitas could exercise its right to say, never mind. Right. So it is possible to table and take that chance if that's our preference. One thing that I think Councilmember, or the sitting council member manager said sparked a question to me that you mentioned that they will not spill any tears if we don't pass this.
Yeah.
So it made me wonder, in negotiation, you don't look at what people say, you look at what their interests are. Is there any sense to believe that the insertion of the no future action was a deliberate poison pill?
So I'm going to answer this from Councilmember Cohen. That's such a, I appreciate you lightening the mood, even though it's not really a lightening the mood, but and so rather than Ms. Rogers answering that, we had so many poisonous pills through this whole process. And we do not think that was one of them. Again, by the time of the conclusion, it was, and that's why we didn't want to take counsel on the back and forth journey of negotiations to this magnitude, but it's all a trade-off. So was it a poisonous pill? No. Was it a trade-off? Yes. Because if it was a poisonous pill, we would have brought it.
I want to follow up on Pro Tem Diversity's question in terms of general versus targeted regulation. That's open to interpretation, I assume. So we can pass something we say is general, but can be sued to claim that our conversation implies it's targeted.
Like the noise ordinance.
Yes.
So even if we say we don't do anything general, even if we say it's general, the claim can be made it's targeted.
Yes, and the court agreed.
Yeah, that was the situation we had in the noise ordinance. There was a huge effort by staff to make it very generally applicable.
Right. And lastly, I just wanted to, speaking to people, obviously there's, as Bruce referenced, a room full of people with PTSD from having to think or deal with extraction. And getting over that distress is a huge hurdle. But I was just curious in this, I want to say minor, but the lesser items in this agreement that would make your life easier, email rather than hand delivering a note on a platter or a monthly plan. Are these things they refuse to do just out of good faith and good neighborliness?
So I can I can speak to the vast difference in how they are responding, how they're communicating. So on Nancy's chart where it indicates that I mean, not only was it pulling teeth to get a schedule, we just didn't get a schedule. I mean, they, you know, I was in a vehicle and went to the pad, just as an example, and the police department had been, I mean, that, it was to that extent. So from a field operations perspective, Mr. Valdez and our inspectors have access, complete access. Their responsiveness has been great. We have 7:30 a.m. check-in calls with leadership every morning. It's a vastly different, feeling. So that piece in there, if it remained to where we are now, which I don't have any indication whether we pass this or whether you all don't pass this, that would change. I mean, I don't foresee them pulling anything back from a staff perspective to allow us ease of access, nor would it impact our ability to enforce the operators agreement, which is really where our focus needs to be, is ensuring that the operators agreement is being fulfilled.
Appreciate that. And one last, I promise, just curiosity. My understanding is Civitas is not here personally and for this hearing. I don't know if they're listening. Were they invited to?
So they are absolutely listening. Yeah, of course they are. They see CDPHE and CODCC are all listening. And they're all frequent flyers, and not to have a light term, Councilmember Cohen, but on the oil and gas dashboard daily. And they track the movement. So yeah, I did not invite them. I think it would have, I don't think it would have been beneficial or constructive.
I appreciate that, though. If you're listening, they know the phone number. I think it'd be worthy of them to call and face the citizens their operations are infecting. Thank you.
Thank you. Any other council member questions? Councilmember Marshall Schick.
Thank you, Mayor. Most of my questions have already been addressed. One question on tabling it for tonight. Is there any indication that if we did table it, there's any appetite on their part to take some of these provisions that we have questions about and renegotiate at all?
I can say unequivocally, absolutely no.
That's what I assumed, but just wanted to check. And I do have one question. I know we have been talking a lot about the perceived of what we are giving up in this, and I want to thank everybody for coming tonight. I know you all have been dealing with these on a daily basis, and your passion has been what has driven this council for a while. But a question on the perceived benefits, on the spuddy versus drilled. So my understanding is that their position is that the wells that are currently spudded fall under the drilled in the current agreement, right?
Okay.
And then they can take and track those at any time then?
Yeah.
And we have no indication, so they could do it tomorrow, they could do it 5 years from now, I'm Chris.
Potentially.
So the agreement on the, so what we're giving in this agreement is that it will be done over with a few, adjustments possibly by the end of this next year.
With those exceptions that are listed, the provided as provisions and then the 5-time exceptions.
Okay. But our position is that drilling means drilling, not spudding, right? So I guess without asking you what the legal strategy, what is a chance, who would prevail in that, if that went to court over whether it's drilled or spudded, I guess is the question.
I can't respond to that, Councilmember. Well, one, I wouldn't want to speculate that far. And then I wouldn't in a public meeting. But we do have a legal memo on that issue.
I want to say too, Councilmember Marshall, one of the pieces of language that's in the that again, the amount of pushback that we received to have them acquiesce is that we indicated completion. Right, so that's a fundamental difference from the existing MOU into the completion agreement.
So in the existing MOU, the residents that are being affected daily by the fracking operations, those could be happening for a while under the current MOU.
Yes.
And this would then allow us to basically have a hard deadline. But, okay, my question to myself is whether or not the trade-offs are worth it, so that's the only question I had.
Okay, thank you. Any other council member questions? I'm going to go next. Can we go back to the 5 exceptions slide? Because council member Marshall made me think of that. And so there are these 5 ways that they can go past 12/31/22. And I would like to know, how can they be proven? How can they be validated and verified? Or can they just say it's beyond our control because the sales are obstructed, or the capital no longer exists, or, you know, they're kind of ubiquitous, I guess is the word. How do we verify these 5 exceptions?
On some of them that we can independently verify it, like price per barrel, right? That's something that we can confirm. On something like access to capital, we aren't going to be deferential to extraction staying. That's not going to be enough. They will have to prove it. And again, in this, as this council is aware, that's where we get into these legal disputes. No, I won't. Yes, you must. And if you don't, I'm not going to believe you that you actually don't have capital until you prove it to me. Well, then go ahead and sue me for breach. All right, we'll sue you for breach. But we have talked about demanding the supporting documents from extraction on the ones that we can't independently verify.
So we can't verify it.
Well, like the lack of availability of the Liberty Quiet Fleet, we can do our own independent research to see if there's ones truly available. Like I said, the price of oil falling below that amount, we can see that that's something that's published. It would be 3, and 4 that extraction would hold that information. We can actually see all litigation asserted. That would be public record. So for 1, 2, and 5, we'd be able to independently confirm those. For 3 and 4, we would demand information from extraction to confirm that that is factual and accurate.
But they don't have to give it to us.
No, that would be, you're right. If they refuse, then there's nothing in the agreement that says they have to prove it.
But nor is there nothing in the existing MOU either.
No, there isn't, but at least we know what kind of fight we're getting into. This is given a green light to stay in perpetuity.
Which is what the ability they have right now.
I know, but this puts our stamp on it saying we're gonna let you. So that was my question. It is. Any other comments from council? Oh, questions. No, we're still in question. Yeah, we're still in question. The discussion comes after we make the motion. Did you have a question? Okay, Councilmember Anderson.
I just have one final question, and that was on the, I believe Phil asked us earlier, and you're beyond the noise and the emissions issues that are occurring now. I think that the main concern that the provision that I heard most about that was of the most interest was the refracking, and that or in the no drilling rig or frac spread except, and there's a second piece to the, I can't find it here. In the language, there's a second. The further, it states, so the operator further agrees not to perform operations on the wells after its commencement of production. And then there was a clause, and I read this one way, and then somebody convinced me to read it a different way, that provided further that operator shall not henceforth enter into new contractual obligations that would require to perform operations on a well requiring the presence of a drill rig or frac spread after such well's commencement of production. So is that, am I reading this correct in this new way that up until the time that the well commences production, they could enter into new contracts. I don't think we can clear, but that would be super helpful to get clarification on that. So as far as Livingston goes, it's in production. So they couldn't enter into new contracts, but they could have already had the pieces in place that they needed. But on the other well sites, they could actually enter into new contracts still.
No, that henceforth is from the date of the agreement. That henceforth from this day, we agree as follows. So it's not henceforth from the production date. Extraction agreed that if we have existing agreements, okay, those exist and that's in the provided, but we will not enter into any new agreements as of the date of this agreement, henceforth, going forward.
Okay, so they couldn't enter new agreements. So we're only at that point of the wishing that we knew what was in their current agreements, that we don't know what's in their agreements.
Correct.
Okay, yeah, no, that is it. Thank you.
Okay, Councilmember Lim.
Yes, I have one follow-up. Is there anything in this agreement that states that extraction will only carry out a certain number of operations at a certain number of pads simultaneously?
No, Councilmember Lim, there's no term like that.
Okay, so we have not seen anything about the schedules that are promised in this agreement. They're all future, and we don't know anything pertaining to those.
No, Mr. Valdez has the schedules.
Okay, but there's nothing in this agreement. Okay, thank you.
Right, Councilmember Marshall.
Thank you, Mayor. I did have one final question. On what might be in their current lease agreements, if we tabled this tonight, would we be able to find that out? They're not willing to give that up?
No.
Okay, thank you.
Thank you. Last call for questions. Next is council's consideration of proposed resolution number 2021-206. Will the clerk please read proposed resolution number 2021-206 by title?
Resolution number 2021-206, approving conclusion of operations agreements with Extraction Oil and Gas.
Is there a motion to call the vote? Councilmember Shaw?
Thank you, Mayor. I move that resolution number 2021-206 be rejected.
Is there a second? Second. Councilmember Henkel. Is there any discussion? No discussion? All right. Will the clerk please call the roll?
Cohen?
No. Sorry.
I know.
It is just to clarify, a yes vote means reject, a no vote means pass.
I figured that out. Yes.
Wait, what?
The motion on the floor is a motion to reject. So if you agree with the motion, you're gonna vote yes to
Was that your
reject.
motion? Oh, I missed it.
It's different. Usually our motions are stated in the affirmative.
I'm glad you clarified. Thank you. So, yes. Okay. Motion to reject.
So Cohen?
Yes.
Hinkle?
Yes.
Jezerski?
Yes.
Leslie?
So I'm not trying to do this. I'd rather make a motion to table so we can come back on it. So should I vote no on this one to come back to table? Would that be the way to do it?
Yes, we're in the middle of a vote, so you'd have to kill the current motion and then make a new motion, not remove.
Yeah, make a new motion once the vote is completed.
Yeah, if this motion fails, then we go back to discussion.
If this all goes, okay, then I'll vote yes.
Lim?
Yes.
Lindstedt?
Yes.
Marsh Holsham?
Yes.
Shack?
Yes.
Ward?
Yes.
Anderson, yes.
Oh, sorry. Anderson. Thank you. So that passes unanimously. It's rejected.
And I just want to confirm what we got, Councilmember Leslie's vote accurately.
Yeah.
Thank you. I just want to make, okay,
Thank
because we
you.
were sort of fine. All
I
right, thank
did
you,
want to
Mayor.
offer a counter motion. How do I do that?
Well, the item is now done,
Okay.
so we could do direction to council, direction to staff, section 18 request, or something like that. But
But
this
wasn't it-
matter is done.
Clear, I want to clarify that there's no more negotiating to be done. This is the deal. It's not going to get any better or worse.
No,
So
I
there's
just,
really no need
okay.
to have this hanging out there, in my opinion.
I understood that. My thinking was more among us that we might come back around to agree to it, even though it may not change, but to better understand it and to better take into account the concerns of our residents. That was my hope. Because I said, I think there are some elements in here that you worked hard to bring benefit to Broomfield, and I hate to lose those benefits. Now, if there's another way to come back to us in the new year with something else, you're telling me no tonight, but that may be possible, depending on probably Civitas and whether they're willing to say, yeah, we heard, we understand, we realize there's a big lack of trust here. We need to overcome that. We're willing to come back with you all, not necessarily renegotiate, but to keep this thing alive. Then I would be in favor of something along those lines. Thank you.
We haven't been doing this for 4 years. All right, well, we're gonna go ahead and take our break for 10 minutes. It's 8:13. We'll come back at 8:23. Thank you for your patience, everyone.
The Access Live event is in music hold. music hold ended.
I'll stay if you're staying. Next is the public hearing and council's consideration of proposed resolution number 2021-197, approving the North Park filing number 2 site development plan. I'll declare the public hearing open. We will follow the city's standard public hearing procedures. First, staff will present a summary of the proposal. Next, we'll have the applicant's presentation, if applicable. Then we'll ask for public comments and finally comments from the applicant. Then we'll have questions from the city council. Council has a copy of the agenda memorandum, which I'll ask our staff to summarize.
Thank you, Mayor. Anna Bertzetti, Director of Planning, will introduce and walk us through this item. Ms. Bertzetti.
Thank you, and thank you, Mayor Pro Tem and City Council. We can have the next slide, please. This application from McWinney Real Estate is being submitted for a site development plan for 2 buildings out of a 4 complex flex office campus. The property is located north of 160th Avenue, east of Sheridan, and west of Huron Street. The project area is within the North Park PUD and is intended to be part of the master planned mixed-use development of Baseline. There are 2 additional flex office buildings, as I mentioned, which are located to the west of this parcel. And then the North Metro Fire Station is located to the south, and Northwest Parkway Authority has a facility in this area as well, to the south of 160th. Next slide, please. The Brookfield Comprehensive Plan designation for this property is mixed-use commercial. The proposed flex industrial building is consistent with this comprehensive plan land use designation. Next slide, please. The property is zoned planned unit development, or PUD, and as I mentioned, as part of the North Park PUD, flex office industrial is a permitted use within this PUD plan. Each of the buildings that's proposed this evening is about 152,000 square feet, and they're each located on 7.73 acre lots. So the total area of the site development plan is 15.5 acres. The buildings are oriented consistent with the existing 2 flex industrial buildings that are located to the west. There is a truck courtyard located between the 2 buildings, and the project area has an existing ingress-egress onto 160th Avenue immediately adjacent to these 2 proposed flex office buildings. There's a second ingress-egress to the flex offices located to the west adjacent to the first phase of development. The applicant is requesting a parking variance, which is consistent with the first phase of development for buildings 1 and 2. The existing parking ratio has not been a concern at the existing establishments. Next slide, please. The proposed buildings will be painted in 3 shades of gray, consistent with the existing North Park Flex Building 1 and the Flex Building 2 that are on, and the Flex Building 2 that is currently under construction. The building architecture has been reviewed by the Baseline Design Review Committee, and they have approved of its design. Next slide. There are 6 variances that are requested as part of this proposal. 5 of these variances were also approved as part of the first phase of development for buildings 1 and 2. All 6 of the variances are detailed in staff's memorandum. The new variance as proposed this evening for buildings 3 and 4 is related to signage. The proposed signage is not anticipated to create negative impacts on the overall campus. A single multi-tenant monument that is being requested will help to provide clear identification for the tenants and is not out of character for the Baseline development. Next slide, please. A concept review for the overall complex, which originally included 5 flex office campus buildings, was completed in 2016. This proposal is consistent with that original concept plan. LERC held a hearing on October 25th of this year and voted 7-0 to recommend approval of this proposal as presented. The neighborhood meeting that is required for this development was held on June 8th of this year, and no residents attended the meeting. Public notice requirements were met. There are no key issues identified by staff in the staff report, and this concludes staff's presentation. Thank you.
Thank you, Ms. Burton. Next is the applicant presentation. Just as we ask staff to keep their presentations brief, I ask the applicant to be concise in their presentation. Will the applicant's representative please identify themselves for the record prior to beginning your presentation?
Hello, everyone. My name is Megan O'Brien, and I am with McWinney Real Estate Services. I appreciate everyone taking the time tonight to review our SDP for lots 3 and 4 in our Baseline community. Next slide, please. So here on the screen is our Baseline community. It's 1,100 acres. It is bordered by Highway 7 to the north, I-25 to the east, 160th Ave to the south, and Sheridan Parkway to the west. You can see that we have highlighted lots 3 and 4 in red. And as Anna has pointed out, we have buildings 1 and 2 next door. So this is part of a 4-building flex campus. Next slide, please. The buildings are 152,000 square feet approximately, and will take up about 45% of the 7.7 acre site. There is also 39% of the site that will go for driveways and parking areas. And then lastly, there's about 15% of the site which will be open space. Next slide, please. As mentioned, these are 7.7 acre sites. These designs are pretty much replicas of building 1 and 2 next door. We've got 4 drive-in doors and 16 dock doors, and these buildings will have 28-foot clear heights. We'll have a parking ratio of 1.2 per thousand as proposed. However, we do have the ability to strike the dock truck courtyard that you see here in the middle, which would bring us to 1.8 per thousand. Our column spacing will be consistent with 1 and 2 as well, which is 52 by 50 feet. Next slide, please. Here are the proposed elevations. As Anna mentioned, this building will mirror NP2 next door. Next slide, please. Here are 2 renderings, one from, this is what the building will look like from 160th Ave. So on the top, you're seeing the office side of the building, and on the bottom, you are seeing the truck courtyard. Next slide, please. As part of our agreement with the Baseline Master Plan community in the city and county of Broomfield, we have a subdivision improvement agreement in place, and that requires us to essentially develop roadways adjacent to our developments. And so as part of this development, we'll actually be widening 160th Ave by about half a mile, as you can see here on the bottom picture on the left, as represented by the gray portion. We are adding a second lane, westbound lane, as well as left and right turn lanes into the facility. And lastly, we'll be adding an 8-foot sidewalk with a landscape tree lawn. And not noted here, but please note that we are putting in bike lanes as well. Next slide, please. Here is our master plan for the immediate vicinity around the site. And what I really wanted to point out here, and we talked about this in past city council hearings, is we've included some buffers to the north and to the east to what is proposed to be an office campus, and to the north to the regional park trailway. Next slide, please. Here is our regional trail network throughout the baseline community. What's really nice about this is people working in building 3 and 4 will actually be able to walk, whether they live in the community or to go grab lunch. They can cross the parkway and head over to the Center Street District, which is where a lot of the retail action will happen. Next slide, please. And for those who prefer to bike over walk, here is the bike lane network throughout baseline. Next slide, please. And last but certainly not least, we know sustainability is extremely important to many of you on council, and is certainly important to us at McWhinney. In fact, last year we created a brand pillar system at McWhinney, and what that means is within each of our developments, we actually have to incorporate sustainability in every project that we do. And here are the ways in which we've incorporated into these specific projects. First and foremost, we've designed the roof to accommodate solar. We are putting an underground electrical conduit to allow for future EV charging stations. We are putting in pollinator and zero planting. We are engaging in the measurable platform, which essentially tracks utility consumption to help guide efficient utility usage. We are enrolled in the construction waste program to help mitigate waste while we're in the construction period. And we have incorporated LED lighting as well as skylights. Next slide, please. Just wanted to end and say thank you all for your time this evening and open up for any questions.
Thank you, Megan. We'll now proceed with public comments. Does any member of the public have comments on this agenda item? Starting with in-person comments, if you do, line up behind the podium and state your name and neighborhood for the record. Not seeing any online. So we'll move on to council questions. Members should limit themselves to questions during this portion. The time to introduce amendments and state positions for or against this time is later. Councilmember Leslie, you're first.
Yeah, I'm pleased to see the effort to pay attention to 160th, but right now it's only a half mile. So is it the intention of McWhinney to extend that all the way to Huron and back towards Anthem Highlands? And do you know how far that's going to go?
I do know that we are going to be building it out all the way to Huron Street as part of our master plan community, but it is not a requirement at this time per our subdivision improvement agreement with the city.
Okay, and do you know how far towards Anthem Highlands it will go?
I do not know. What I do know is that we are required to improve the streets that are directly adjacent to the developments that we're working on.
Okay. Does staff have a response?
If I can add in, yes, the obligation for the improvements for 160th does go all the way to about the community ditch for the future improvements. But as was mentioned, it is based on the traffic analysis and when it is warranted.
Okay, but right now that half mile is in fact part of the expectation that's going to be improved.
Yes, as was mentioned, there's an existing subdivision improvement agreement that was done concurrent with the first 2 buildings, and it establishes the need for these based on the traffic studies we're seeing that this is going to be needed to be done with this building by about 2025. So it's being done now.
Thank you very much.
Thank you. Councilmember Ward.
Thank you, Mayor. My question is in regards to the bike infrastructure that you have proposed. I'm very happy to see that it's something you've been mindful of. But the bike infrastructure that I see on, say, 160th, Huron, and the Sheridan Parkway looks like it's supposed to share the road with cars. Am I correct with that assumption?
So there will be a 2-foot buffer between the travel lanes where the cars travel and the bike lane, and then a 5-foot bike lane, but it is within the curb, yes.
And that 2-foot buffer, is it just 2 lines on the road that are more or less suggestions for cars to not cross over, or will there actually be physical barriers? to protect bicyclists?
It is striping.
Okay. And then what kind of bike parking have you placed on the actual campus itself?
We do have some bike racks on lots 3 and 4, which we're discussing here tonight, and then we'll also have bike racks throughout the community as well.
Is there a certain number of bike racks that you're proposing for the development, or how do you go about figuring out how many bike spaces you want to put in?
I believe we have a bike rack on each end of the building as currently designed.
Okay. And then, I think that's my only questions for the time being. Thank you.
Okay, thank you. Councilmember Chap?
Thank you, Mayor. So my questions continue off of where Councilmember Ward was talking about the bike infrastructure along 160. Currently, right now, there is no bike lane on that road. Is that correct?
I believe there is a bike lane. I might ask Anna to speak to that. It's actually, I think, now that I'm saying it, as we improve it, we put it in, and I do not believe there is one.
Right, luckily I just wrote it today and I do not recall seeing one, so I don't believe it's part of the current improvements. But during this phase of the expansion, there will be a bicycle lane added.
Okay, and then you also had mentioned that with the traffic study, it did show the need to expand the automobile capacity on this road as well, correct?
That's correct. So there's an additional lane being added as well as the auxiliary lane for the turn. I believe that was the additional.
Perfect. All right, thank you so much. That's all I have, Mayor.
All right, thank you. Councilmember Anderson?
Thank you. And my main questions are about the road as well. And that is a road I travel every single day as I take my kids to school. So I go back and forth on the road way too frequently. And I've seen bike riders try to use that road and they basically ride the white line. And we have semi trucks and vans going down that road. It is a very, very dangerous road. So my question is, I appreciate the widening of the road in conjunction with this project. But then there's that 1,930 feet from the edge of that to here, I was noted in the packet. And you know, it's great if we can get that section underneath adjacent to these buildings to increase, but then it just disappears. So all the benefit of the bike lane wouldn't be realized until we had development at some stage. I think this is actually a question maybe for Anna. About what does that date look like? I mean, it would coincide with development of that final section, or could it come sooner if a traffic study indicated it would be sooner?
So there's an existing managed growth and development agreement for baseline, which outlines that road improvements are tied to the track boards when it's needed. In addition to that managed growth and development agreement, we also do individual subdivision improvement agreements as projects come through, which further specifies the timing and ensures that we get surety for those improvements being made concurrent with development. So it's a little bit of both in terms of will it be warranted and would the MGDA, the managed growth and development agreement, require it, or whether it would come first with a development probably adjacent to the site and then be tied to a subdivision improvement agreement. I don't have a timing for it. We haven't seen any conceptual plans specific to those parcels to the east. I'm not sure if McWinney has any additional detail about the timing for that.
And one more question for you, that could be something that McWinney could do at any point in time. They could come forward and say, we just want to widen the entire length of that road. We've got Amazon distribution center. We've got these, this is a busy road. They could do it.
Theoretically,
yes. Okay.
An adjacent property owner could come through and ask to do a public-private improvement permit anywhere in the city adjacent to their property.
Okay. And then one final question is on sustainability. I saw, so this is for Ms. O'Brien. So it is either solar ready rooftops, and just a question about what's the feasibility of there actually being solar? Like, is there any chance that McWinney would just add the solar because it was cost justifiable, or is there any chance that a tenant would add that solar? Because it's great that's rooftop ready, but until it actually hits the panels, it's not. Maybe that's it.
All right. Now, Councilmember Leslie, you raised your hand, but I'm gonna finish the first round first, and she already spoke, so I'm gonna go to. Oh, there's a question? Yeah. Oh, yeah.
So your question was in regards to what is the likelihood of solar panels actually being installed on the building versus us just designing to accommodate it? And pretty standard in this market is to have that be included as a tenant improvement. And so there is certainly a chance when a tenant comes that could happen. I'll give an example with the EV underground electrical conduits. We are currently in negotiations for a full building user on building 2, and they have already stated that their intent is to move forward and put in some EV charging stations, which we're really excited about. And so similarly, that something like that could happen with solar as well.
My apologies, Councilmember Anderson. Councilmember Marcia Holton.
Yes, thank you, Mayor. So going off the question from Councilmember Ward on the bike lanes, is there a reason why the bike lanes are not dedicated and barriered between the street and the?
I might let Anna answer that because I believe what we do is follow code.
Thank you. So council members, our engineering division establishes standards and specifications for all of our roadways. Part of that is looking at bike lanes. Buffered bike lanes are currently our requirement on the major arterials. Some of the issues that we have seen, and this is a little bit out of my area of expertise, but in my experience, the discussions I've heard is that it's primarily snow removal and some of the maintenance that goes into the actual physical barrier that becomes an issue for us. And so it's one of the challenges. We're definitely always looking at opportunities to make changes where appropriate to our standards and specifications. But in this case, McWhinney's development for the PUD plan for baseline specifies that it can be a striped barrier in this case. So those street sections are established in their PUD plan in addition to being consistent with our standards and size.
So it's something we can discuss moving forward in the future, but not for this particular project tonight.
In this particular project, because these street sections are established in their PUD plan, the street sections as proposed are consistent, but we can definitely continue to look at the barriers.
Thank you.
All right, thank you. Any other first round questions from council? We'll go to you, Councilmember Ledford.
Thank you, Mayor. Actually, I just want to follow up with Councilmember Anderson's kind of follow up to my question. What concerns me is that half mile is great, as I said earlier, but it's only part of it. And given the anticipated development that McWhinney is doing, one would hope that they would say, let's just do it all now. So I'm just simply speaking on my own. I can't, speak on behalf of the council, but I would invite McWhinney to go ahead and do that whole strip. So we don't have somebody on a bike lane for half a mile, and then the next half a mile, there's no bike lane. And there's trucks coming out and all that stuff there, let alone the drilling that's going on over there as well, the trucks from that, which we haven't even mentioned. But it just seems like good citizenship would be, we know we're gonna have to build it anyway, because given the whole development of baseline, let's just do it now. So that's just what I'm asking you to communicate to your company. Thank you.
Absolutely. Thank you for your comment.
Thank you. I like that. Anything else? Okay, there being no further questions, the public hearing is closed. Next is council's consideration of proposed resolution number 2021-197. Will the clerk please read proposed resolution number 2021-197 by title?
Resolution number 2021-197, approving the North Park filing number 2, replat C, lots 3 and 4, site development plan.
Is there a motion?
I'll move it.
Councilmember Ledford.
But the expectation is by my moving it, she's going to communicate to.
Second. Thank you. Well, is there any discussion? Okay, go ahead, Councilmember Shah.
I was just going to say, I appreciate the developer bringing this forward. It sounds like the success from lots 1 and 2 have been tremendous. They're coming back with 3 and 4, which shows me that there's one demand for this, which I think we've heard from our economic vitality that there is demand for the flex space, and as 2 as well as this is a great location. So I look forward to the success from this project, and thank you again for bringing it to Broomfield.
Thank you. Anybody else? All right, will the clerk please call the roll?
Hinkle,
Yes.
Jazerski. Yes. Leslie,
Yes.
Lamb,
Yes.
Lindstedt,
Yes.
Marsh Holstrom,
Yes.
Shaft,
Yes.
Ward,
Yes.
Anderson.
Yes.
Cohen.
Yes.
Thank you, that passes unanimously. Thanks y'all for being with us this evening and for your patience during that first item. Our next item under council business this evening is the monthly oil and gas update for December 2021. Council has a copy of the agenda memorandum, which I'll ask our staff to summarize.
Yeah, I appreciate that. And Andrew Valdez, also Megan, Dr. Megan Weisner is here in the audience to field questions as well. And with that, Mr. Valdez.
Thank you, Manager Hoffman. Good evening, Mayor City Council. So for the new members, I am Andrew Valdez. I'm the Director of the Strategic Initiatives Department, and the oil and gas programs sort of housed underneath my purview. So I'll be giving the December oil and gas update tonight. The format is essentially an overview of the observations, findings, and highlights from each programmatic area, starting with inspections. Next slide, please. So first, a quick update on the Shannon Roberts Orphan Wells in Northern Broomfield. The COGCC is attempting to collect on a bond from the now non-existent operator. This will be before the commission on January 12th. And if they're able to collect, we'll hopefully see those wells and facilities decommissioned and cleaned up not too much after that. We have an active remediation on one of those wells, so this would be a win for us. We also observed 2 wells plugged and abandoned in the past 2 months, the Priest 35-1 and the Nordstrom 1-5. And finally, as a reminder, we've gone to 7-day-a-week coverage with the resumption completions activity on the extraction pads, which has been a topic of conversation this evening. Next slide, please. Soil gas testing, we continue to make progress. In the week of December 6th, we located an additional 6 wells with a magnetometer. And based on the locates that we've done so far this year, we're retesting 7 wells for subsurface methane this week, all of which are in Anthem. And in my email to you guys earlier this evening, there's a map and a list of all those wells in case anyone wants to look that up. As a reminder, we have brought the magnetometer survey effort in-house, and by my calculations, we've saved about $20,000 so far. And then finally, for open space acquisition diligence, the Carlson 43-6 well will be soil gas tested sometime in January, along with some other confirmatory environmental work. Next slide. All right, moving on to air quality monitoring. So our next full quarterly update on air quality monitoring with our specialists team will be in February, but I want to provide some high-level observations from the recent activity. From September 2nd to November 15th, we've collected a total of 49 automatic air canister samples, and the majority of these can be correlated to active downhole drilling within the hydrocarbon formation on the different pads. We have not really seen air quality events from fracking as it's been closed loop. However, there's been at least one event that we believe to be associated with the mill out phase. This is the phase that happens after fracking. This is an event from December 4th that triggered 4 canisters within a 1-hour period. And we saw a significant elevation in methane recorded at the North Pecos air quality monitoring site. Data for this event is still being QA/QC'd, but I anticipate to have a report on that event probably this Thursday. For new council members, our air quality monitoring consultants provide 1-hour estimates of VOC concentrations observed in the 60-second air canisters. This is so we have something in our air quality data to kind of benchmark against an acute exposure. The CDPHE defines an acute exposure as intermittent exposure lasting from several hours to several days. One of my goals for early 2022 will be to validate this methodology used to calculate the 1-hour estimates. And what we're looking at doing is essentially putting a valve restrictor on the 60-second canisters so we can do like a 10-minute sample or a 30-minute sample. And then that way we're not multiplying by 60, we're multiplying by 2 or 3, right? So stay tuned for that. In any case, the 49 triggered air canisters we've collected in the past few months, 8 of those have estimates for contaminants of concern higher than established health guideline values for a 1-hour exposure. We, of course, share all this information with the Air Pollution Control Division at the state, who is the regulator of air quality and emission sources. And I believe we now have a date and time in January for council to review this topic with the APC. We have also recently received a report from a plume tracker run on also on December 4th, where we did clearly identify an emission from the United Pad, again during active downhole drilling. Elevated methane was observed, however, main contaminants of concern were below health guideline values for this particular event. That plume tracker report is also included in your materials today. Next slide, please. All right, noise monitoring. So by far, fracking is the loudest phase of this project. As we've discussed, there are thresholds in our operator agreements, which Broomfield contends have been violated. We have sent 7 notices of alleged violation to the operator, and we're proceeding under our dispute resolution clauses outlined in our operator agreement. The next step is a meeting with extraction representatives who will present our evidence, insist that future fracking be below thresholds, and request to be made whole for the impacts already experienced in our community. Next slide, please. And then finally, an update from the policy and rulemaking shop. So first, Coslet East. As a reminder, this is in Weld County, but proximate to the city and county of Broomfield. Our internal analysis shows 15 wells within the proposed spacing unit that we believe should be considered for plugging and abandonment before development can take place. This includes low producing shut-in and temporarily abandoned wells. We have sent our analysis to representatives of the operator, and we'll hold a meeting in the near future to discuss. We will also continue to work through the formal consultation channels with the COGCC, who of course has final permitting authority. Next on financial assurances rulemaking. Broomfield, along with the affiliated local government coalition, presented to the commission our consensus comments on the latest version of the rules. We covered assurances for low producing wells, scrutiny of transfer for assets, timely plugging and abandonment once a well has reached the end of its useful life, hearings requests for local governments and surface owners, and full cost bonding. Our next filing is not till early January, so we will see how our comments were received and respond accordingly. This is something we're coordinating with our outside counsel as well. Lastly, the Air Quality Control Commission, GHG rulemaking. The local government coalition is supporting the Air Pollution Control Division's current proposal, which expands current leak detection and repair requirements. Primarily, the proposal increases the frequency of inspections at emitting sites. Under the current rules, operators only need to inspect small sites once in a lifetime. And this proposal would mean the state would go to an annual cycle. Broomfield already has its own leak detection program, and we inspect all active sites and facilities on a quarterly basis. But of course, GHG emissions impact all of us, so we remain engaged in this process. So that's the update from me. I'll turn it over to Dr. Weisner for the public health update.
Thank you, Mr. Valdez.
Thank you. Good evening, Mayor Pro Tem and City Council. I'm Megan Weisner. I am the Senior Environmental Epidemiologist in the Department of Public Health here at Broomfield. So it's nice to see some of your faces here tonight. As many of you know, the City and County of Broomfield Public Health Department is working very closely with the Colorado School of Public Health at the University of Colorado, Denver, and Anschutz campus. We're working with Drs. Lisa McKenzie and Dr. William Alshouse to further the understanding of health implications of living near oil and gas development. In October and November of this year, a health survey was sent to approximately 3,900 households that were randomly selected all throughout Broomfield, near and away from oil and gas sites. In early December, the target sample size was reached, so this is really good news. We will have a very robust analysis that will occur with very strong validity. So we're continuing to collect survey responses through the end of this year to further strengthen the findings of the survey. After the data collection period has concluded, we will begin our analysis.
So in late January 2022, a preliminary report will be made available to City Council summarizing the distribution of responses and basic demographics of the respondents. So this is by no way a full analysis. This is just the beginning phases, but we will keep you informed on all the phases as we work through this analysis. And of course, as you know, if any interested residents or council members would like more information, there is a website at the bottom of this slide. That concludes my presentation. Thank you.
Thank you, Dr. Weisner. We will now proceed with public comment. Does any member of the public have any comments on this agenda item? We'll start with in-person public comment. And if there's anyone who would like to be heard, please come to the podium, state your name and neighborhood for the record, and limit your comments to 3 minutes.
Hello, Kristen Logan, Anthem Highland, and I'm not going to speak a lot. I feel like I might have already spoke a little too much tonight. I'm just here to put a face to the impacts. It's hard to correlate nosebleeds to these types of activities. Since drilling has started, I've been tracking nosebleeds with my own child, and they stopped when extraction went up to bankruptcy. So during that entire time that we didn't have extraction really in the picture, limited, maybe 1 or 2. The impacts are real, they're happening. I realize that we could all do a better job reporting at the same time. It's not just report fatigue, it's also like nobody's listening. I feel like we're in the game of a hot potato between the state and city. We've got health impacts, we've got problems, and everyone's just tossing the potato back and forth. Who's gonna handle it? Who's gonna handle it? But we're now talking about 8 instances of benzene levels that are above health guidelines, 8. We don't know how many more we're gonna have. We don't know how many we had at Livingston. The fear is real. The fear is real about cancer at this point, about leukemia. Every time my child has a bloody nose, I wonder if that's a sign that it is leukemia. Do I need to take her to the doctors for blood panel, blood testing? I watch my kids for bruises, like constantly. How much the bruising, how hard the bruising, and then myself. If I run into a door and I get a bad bruise, I'm like, oh my God, do I need to go to the doctors? The fear is real. And what makes Broomfield different than other communities realizing this impact is we now have numbers which substantiate that there's really high levels of benzene, which is a known carcinogen. So a lot of people say, wow, everyone's so lucky in Broomfield. You have your air monitoring, everything's so great. You guys must be so grateful. And I'm just like, actually, no. And sometimes I'm not grateful because I know that I'm being exposed to high levels of chemicals that could cause cancer in me and my family. So that's the reality. That's what it feels like living with this. And now that we're getting recordings and numbers that are above health guidelines, it's scary. It's really scary. So that fear that's in us, it motivates us to be engaged and be passionate and just know that we're here because me personally, I'm afraid. So thank you for your time.
Thank you.
Hi, Mackenzie Carrigan, also Anthem Highlands. Again, to kind of put a face to impacted residents. My story is that my family had a chemical exposure thanks to the Gibson mud that was being used in 2019. We had our whole house fan on, and when they were drilling in Livingston, we sucked a chemical plume into my house. It was extremely traumatic. My children were gagging in their beds. Our eyes were burning. It was probably one of the worst experiences we've ever had in our lives. And to watch your children go through that, it's just a horrible experience. I pretty much had a chronic sore throat since that experience. No one can really explain it, but it's real. I have a child with chronic nosebleeds. I have a child with cluster migraines. We have been looking to correlate the chemical spikes with his migraines. There's a lot of pretty clear data that shows that when the toluene levels are high, he starts to get these cluster migraines.
So it's really happening. There's a lot of us who are impacted by this, who are tracking these. We report as much as we can. But it's a very exhausting experience to be in having these impacts and then to have to report them. I know that probably sounds like a stupid thing to say, but to watch your child hemorrhaging from their face and then to have to go 10 minutes later and fill out a form about it, it's just, it's really hard. So we're doing our best with that. One thing I would like to emphasize though is, we have these 8 events on record of these air quality events, these 8 over the established health guidelines. When we had a meeting with Detlef at one of our oil and gas Wednesday meetings, whatever, what he said was, for every 1 chemical spike we're measuring, there are 30 out there that we're not measuring. So I wanted to just, I know everyone here wasn't at that meeting, but I think that's a really telling statistic that I feel like we should really kind of drill into our minds. So if we're seeing an event of 100+ parts per million benzene, we're seeing 1 of those and then 30 of those are happening and they're traveling to our playgrounds, they're traveling to our open space and recreational areas in our neighborhoods, and they are impacting our children. We see it every day. So I just, again, wanted to kind of put a face to the impacts, and this is why we're so passionate about these things. It's why we are here and why we are engaged at our houses and why we probably work 20 hours a week for free doing this. So it's something that we're very passionate about. So thank you. Thank you for listening.
Thank you. Anyone else? I don't see anyone online. So questions from city council are next. Are there any questions from council? Councilmember Anderson.
I do have a few questions. I'll keep these, hopefully keep them brief. On the noise, extraction beyond the 30-day cure period, and it sounds like we haven't had a meeting yet. So refresh my memory on this. There were some mitigation methods. One of them was a material that could have to absorb the noise, and we've made those recommendations, but as of now, they've only put additional hay bales and sun walls, correct?
And some operational adjustments, which I would be hard to verify.
And then we expect more to come after the meeting with potentially.
Yeah, I don't, can't speak for them.
Okay, so for now, we do the potential option if they agree to that sound material, which they objected to so far, could.
I think that's a thing we could insist on in the meeting, it could be engineered, right? Whether or not they're gonna do it, we have a dispute resolution process. We'll go through that process and update you guys as we go forward. But I don't know if they're gonna do it. We'll play our best hand.
You know, magic ball. Okay, I'll let that go. Okay, thank you. And then with the emissions, and this just reminded me, the CDPHE, one resident had reached out to some of the CDPHE who noted that there were so few complaints from Broomfield. And then I clarified for this person with CDPHE that actually the most impacted residents currently are actually Adams County residents. You wouldn't see that data in Broomfield, but that just brought this whole conversation up. Have we made progress? This is for the CDPHE meeting, I think, to ensure that we don't have residents file them twice. Like if you file with Broomfield, you shouldn't have to file with the CDPHE. Have we had that discussion with the CDPHE to look at data sharing?
Not really, but I mean, a complaint data set, whether it's their data or our data, especially if it's resident driven, I think it's fine. And I think could be one of the topics of conversation we do need.
And then,
I'd like to address that, Councilmember Anderson, Jason Bowling, Director of Public Health. Actually, we entered into a data sharing agreement with CDPHE when we established our health concern program. And we have monthly meetings with CDPHE, which includes their environmental epidemiologist and their toxicologist, along with their air experts. And we go through and ensure that we're not doing that. So we may they may see few reports coming from Brookfield, but we're sharing the data that we're receiving from Brookfield with them.
Okay, yeah, that's helpful. Thank you, because that's really important. And then on the extractions regs said AQM plan that they required to put in place. I just want to make a note of this. I don't know what the question is for you, Andrew, but their threshold is 5 parts per million, which I don't think you're not really great with math, but that's 5,000 parts per billion. And we're trying to detect, and that's on the total VOCs, but we're trying to detect 9 parts per billion is the threshold. I guess that we credit the state why the threshold is set so high. Like, are they just looking for not they're not looking at a health perspective, but more of a serious emissions violation?
No, it's a good question. So a couple of clarifying points. So the threshold that would trigger collection of the benzene tubes, which they're doing per Reg 7, is 5 parts per million of total VOCs. So when we see a plume, we're seeing a lot of different airborne contaminants. And benzene is one of the lightest. We use benzene as a marker because it's one of the lowest health guideline values. But total VOCs can be in those parts per million, orders of magnitude. What we've seen in their data so far, which they've actually shared with us whenever we've asked, we get these monthly reports from APCD, but Extraction has also shared with us snips of their data whenever we've asked for it when we see a large event. And again, the threshold is 5 ppm over a 4-hour period. So I think that would be indicative to them of something went wrong. It's the Air Pollution Control Division. It's not the Health Division that's regulating this. So again, I think they're looking at it from a perspective of what did something fail operationally. But again, a good question for them.
Okay, thank you. And then I think this one should just be brought up one more time on the Coslet East pad. And I want to verify something that was said in the last oil and gas meeting. I think it was that we have been looking at, we've really been weighing in on getting those wells plugged and abandoned, which is a really
Shannon Roberts or
no, the Coslet East pad, the new Coslet pad. To try to ensure that we're flagging that we want all of the wells in that spacing unit plugged and abandoned, but we also, it seems like we're kind of weighing in now. I just want to revisit that conversation of should we be weighing in on the greater conversation of cumulative impacts now, or is that just want to make sure we're not missing?
So let me talk a little bit about cumulative impacts. That was set up as part of state rulemaking processes as a database. Right now, that's an empty database. And what the state is requiring is in new proposed plans, as part of your well designs and all the rest, you also need to submit a report on cumulative impacts. We've heard from the COGCC that this has no bearing on whether they can approve or deny a permit. It's just a requirement as part of a submittal package. Maybe it will be someday, and we would love to see that. And, I have in my mind this robust data set that, has been validated over, some time. And we actually know, like, you put this many wells in the ground, this is how much you're impacting water. This is how much you're impacting health. This is how much you're impacting air. As it is right now, cumulative impacts is just an empty database, and it's just starting to be populated right now. That's what that is.
Okay, thank you for that clarification, and that was all my questions.
All right, thank you. We actually have someone on the line that would like to comment. They came in a little bit late, so I'm going to allow it. Kathy Swan Bogart, you have the floor. You have 3 minutes.
Can you hear me?
Yes, we can.
Are you? Okay. So I just wanted to follow on a couple of the other citizens that made comments about the health and some of the problems that they're experiencing. So for those of us that live close to Interchange, we had to breathe Gibson for 4 months. And I want to send council the safety data sheet for Gibson tomorrow. It's not a little bit of benzene, it's like almost all benzene. And so, yeah, that's why people were getting sick. It also has a unique odor. It's very strong. It's very pungent. To me, it smells like the Greeley Stockyards mixed with burnt hydrocarbons. Other people describe it other ways. But some of the health effects that we're having around here are related, they are this industry, and they are what we are being exposed to. And the AQM that we have is poorly measuring our benzene, as one of the people that spoke a few minutes ago stated. There may be 30 more events for every one that is reported and captured in the monitoring. And that's it. Thank you.
Thank you very much. Back to council comments and questions. Councilmember Lim?
Yes. I cannot express my disappointment in what I just heard Mr. Valdez say about the COGCC saying that cumulative impacts have no bearing on the permits at this time. Obviously, I was hoping it was going to have some impact on Coslet East, but definitely if Acme comes forward, I expected cumulative impacts to have some bearing on that. So I'm interested if staff wants to research this further. What was the intention of 181? I think we have a consulting attorney that we could ask that. Would staff be interested in pursuing that a little further? I mean, if we have a chance to test out what cumulative impacts mean post 181, I would hope we would try to do it in Coslet East already, so that we have a ground to do it for Acme if that comes forward. So I'm interested in any comments on that.
Hi, Councilmember Lim. So cumulative impacts is a technical term with the state. That doesn't mean that our health impacts, our air quality impacts, our noise impacts that we have high quality data on carry no weight when we have these consultations with the COGCC. It just shouldn't be framed in a way of, oh, well, you passed cumulative impacts, now you need to do something about it. So, whenever we're in front of the COGCC, we've made it clear we're having these impacts and here's the proof. But using the term cumulative impacts in that technical way is perhaps not the right term. Does that?
I understand your distinction in the technical term versus the way we have the data to show cumulative impacts. I still am concerned about what the COGCC is going to look at if these permits came forward. With regard to Coslet, or if Acme came forward, if there's a technical definition of cumulative impacts that the COGCC has, is everything are they even going to bother to look at our noise and air quality?
I honestly think they would. But again, in the permitting process, cumulative impacts is the thing that I just described. Impacts, whether they be individual or cumulative from the Broomfield perspective, carry as much weight as any consultation with the COGCC.
Okay, so then why are we not bringing our data forward at this point with Coslet?
We have.
Okay, we have. Okay.
Yeah, Mr. Valdez, let me, so again, two things. A cumulative impact from COGCC's perspective, and the reason that it's included in 181 is as we move forward collecting data, you will see over a period of time what that cumulative impact is. From Broomfield's perspective and from a technical perspective, having data collected over a year and a half does not make a cumulative impact. So that's the combination between having the impact and having, whether it be causation or correlation. So we know that causation is going to take a decade from a health perspective. The shorter term is having enough data over a period of time that then integrates the health impacts and the health studies from all surrounding communities, that then they can draw some conclusions from the operation to the impacts. That's what they consider technically to be cumulative data. We haven't collected enough to have what they consider to be cumulative data. To Mr. Valdez's point, to say that they are not going to be considering the impacts from the data that has been provided daily, weekly, I don't want to say fair, but that's certainly not their intent, and it certainly isn't our understanding, nor what we've seen from COGCC.
Yeah, they want to see this stuff.
Okay, thank you. Why are we not receiving the Reg 7 reports from the COGCC? We have the interchange report from September. And extraction is required to file a Reg 7 report for every pad every month. And we only have one from September, and that one pad wasn't even in the pre-production phase.
Yeah, so this is the APCD, not COGCC, and I actually got an update on that today, because I also noticed they're still going, this is a new reg, and I think they're going through some kind of growing pains right now managing this data. I think they should be delivering those reports to us pretty soon. We've requested those again.
Okay, this, on the subject of backlog of reports, are we, you alluded to the December 3rd into 4th incident where we had 5 triggers go off in at different locations in a 4-hour span. So, I mean, that is of great interest to the community, and that's unprecedented. We've never had that before. So, you know, that it's sitting in the backlog. So the backlog is about a month long. You know, that seems like an interest, item of interest, as you described now, with possibly related to the mill out. Are we going to be able, I mean, they tried to expedite the release of these reports previously. Do we see any light at the end of the tunnel on this?
Yeah, so as I mentioned, Councilmember Lim, I think we'll have the data QC'd by Thursday for the December 4th event, which will include actually 6 triggers that we saw outside of that 1-hour window. It was actually a 12-hour window where we saw 2 other triggers. So we're going to have 6 there, and then we'll have 6 still pending from Ajax, which will take us up to present. So 12 total, which will have a 12 or 6 out by Thursday.
Okay, that's good. The other good news was that we're going to try to have the canisters with longer grabs. We've been talking about that for a while, that was good news that you're talking about trying to validate that methodology too, with where they extrapolate the 1-hour benzene level from the one minute grab. So that was good news. We do have a question that a resident asked that I wanted a clarification on. The resident asked, why are we keeping the northwest pad at 300 TVOC level instead of moving it to 500? We moved the United pad to 500. We've still got the northwest pad at 300. And the residents' contention is that if we moved the northwest pad to 300, we would capture better peaks and we would end up with possibly higher benzene levels, you know, that we would have more than 8 exceedances of benzene health guidelines.
Capturing more the peak of the event. So again, I guess I'd reiterate, this is something I can explore with Ajax if there's a good case to be made there. I think the frequency of canisters that we saw for drilling is quite a bit more, and we've only seen one. It was a significant one. We've only seen one from mill out. So I'm not sure we would want to take the risk increasing the threshold and potentially missing lower magnitude events, but let me explore this with Ajax.
Now, Jean, I'm sorry, Councilmember Lim, our city and county attorney Nancy Rogers had some answers on your question on the COGCC rates and cumulative impacts. Ms. Rogers?
Thanks, Madam Mayor. Councilmember Lim, our outside counsel Mike Foot is actually in the room, so we were just communicating about that. It was in Senate Bill 181 that the COGCC was going to implement regulations that took into account cumulative impacts. They have not yet to date taken action on that task and don't really have a timeline for when that rulemaking is going to start at this time. So, and thank you, Mike, for that information.
Okay, thank you.
All right,
And do we have a date for the noise meeting with Extraction? This is simple.
We do not. We're attempting to schedule that right after the Christmas holiday.
Okay, thank you.
All right, thank you. Councilmember Shad?
Thank you, Mayor. So I appreciate this monthly oil and gas meeting. It's good to see you in person as opposed to on Zoom. I just want to say that I appreciate the role that Mr. Valdez continues to fill and the Herculean task that Dr. Weisner continues to carry. It's not lost on me that, during the presentation, you stressed that this is a 7-day, 7-day work week. That is required by oil and gas operations here in Broomfield. So, thank you to, all of staff that continues to work on this. All council colleagues, the residents that dedicate large amounts of time to dealing with oil and gas operations here in Broomfield. So with that, what is the status of the strategic initiatives hiring? It was mentioned a little bit in the memo that some of that stuff is outdated. So I was curious what the updated hiring prospects look like.
We're going through the final rounds right now, actually, for the oil and gas manager. Our top choice decided that this wasn't the place that he wanted to be. So we are now moving to the remaining 4. Actually, Mr. Valdez, Mr. Allen had 2 interviews today, and the interviews will continue through the week.
Great. Well, thank you for that. And I do hope that you all can, that the burden will be spread and the load will be carried. So thank you for what you continue to do. You mentioned the plume tracker, and this is always something that I like to get information out of because it's the one piece of, it's kind of a tool that we can see what is coming off of the pads and what's coming from the northeast. And I wondered if this is a question that I should wait and hold off until we have our visit from Ajax as well as Boulder Air, actually Ajax, to kind of find out what that one trip looked like. Did they capture that the emissions from the northeast of those pads, or did they just stay to the southeast of the pads?
You're talking about the methane we saw from Weld County?
Right. Well, from the plume, there was that one plume tracker, I guess, action that you mentioned.
Right. So historically, we had seen methane migrating from Weld County. I thought that's maybe what you're talking about. So yes, the Plume Tracker report indicated that, again, we kind of timed this so that they'd be in the hydrocarbon zone at United, and the wind was blowing north and east, and we did see elevations of methane and benzene toluene, that's the benzene xylene VTEX species, along Huron and 160.
Okay.
As it went further south, where they were doing active mill out, we didn't see any elevations of those species, but it's kind of sometimes you catch a fish, sometimes you don't. The VTEX, these are also 60-second canisters. And we were seeing, benzene in the orders of 5-6 ppb. So to extrapolate that out to a, quantifiable health guideline benchmark still remains a challenge, and that's why we're working on validating those canister results.
Okay, excellent. Well, I look forward to the visit from Ajax and Boulder Air to get more information on that. But thank you both for your work on this. I'm glad to hear that we have enough surveys out there on residents participating so that we have a robust study. So excellent news. Thank you. That's all I have, Matt.
Thank you. Any other council member questions or comments? Excellent. Well, thank you so much, Mr. Valdez and Dr. Wisener. I'm excited to hear the update on the health study. It's good news. So, and Jason Bowling, thank you as well for being here. Next is council's appointment to the Broomfield Housing Authority Board. And consideration of proposed resolution number 2021-195, decommissioning the Housing Advisory Committee. Council has a copy of the agenda memorandum, which I'll ask our staff to summarize.
Thank you, and Danae Beauregard. She and her staff are really credited with having moved through these boards and commissions over the last few months and done a real yeoman's job of narrowing them down into what council has to do, what they want to do, and consolidating. And I'm on the wrong topic, so no one's looking over at me. That's the next topic. So I take my glasses off and all hell breaks loose. Danae, I apologize. You're going to walk us through the Housing Authority, and I know that Mr. Romine is here to field any additional questions. Please walk us through this item.
Absolutely. Good evening, Mayor Pro Tem and Council, Danae Beauregard, City Manager's Office. As you recall, and for some of you, this happened before you were sworn in November, but on October 12th, Council approved Resolution 2021-182, which approved the formation of the Broomfield Housing Authority. It's effective on January 1st, 2022. Staff has recruited applicants for the 5 positions. We opened applications from November 4th through the 28th, using the recruitment process that we've used in the past for boards and commissions. We did do an enhanced community outreach plan, which included, it is hard to do this in a mask, so I'm going to take it down, which included specific communication to the current members of the Housing Advisory Committee, as well as diverse populations with experience directly related to housing and lived experiences. Applicants were also encouraged to complete a recorded interview via Spark Hire. We received 9 applications and 8 did complete the Spark Hire. In the past, the tradition of council has been to see all of the applications regardless of if they participated in the interview or the Spark Hire. So that's why you received all 9 applications. The applications that were shared for you were shared on November 22nd. And tonight is your opportunity to appoint the applicants for 5 positions. We have 3 4-year term appointments that will expire on March 2026 and 2 2-year term appointments that will expire on March 2024 at the end of the month. The reason for March is it puts it in cadence with all of our other recruitment cycles so that we can keep it intact with the every other year recruitment that we will do with our other boards and commissions. The process for council to appoint the 5 new members to the Broomfield Housing Authority is to first nominate applicants. If the number of nominations exceeds the number of appointments available, council will then vote using the electronic voting portal. I know this is new for some of you, but otherwise it's the practice that we've used in the past. So I just sent you all the link. There's 2 links in there. We're going to do the 4-year terms first and the 2-year terms. So if you want to go ahead and get that up and get your devices ready while I finish the staff presentation, that is perfect. Let's see, we also have Kateria Beta, our IT director, and Pat Gilbert, our deputy city and county attorney here tonight. They'll help facilitate the voting process. After council's appointment, I just want to remind, there's a second part to this memo that's a little tricky. We'll come back and then have council's review of resolution 221-195, which is to decommission the current housing advisory committee effective December 31st. So essentially, we would sunset that on the 31st and the Broomfield Housing Authority would take place starting January 1. And the reason for that is the creation of the Broomfield Housing Authority essentially negates the roles of what the current Housing Advisory Committee is doing. And with that, that concludes the staff report.
Thank you very much. We'll now proceed with public comments. Does any member of the public have comments on this agenda item? We'll start with in-person public comment. If there's anyone who would like to be heard, please come to the podium, state your name and neighborhood for the record, and you'll have 3 minutes. Well, I'm not seeing any online either. Questions from council or next members should limit themselves to questions. I don't think we're doing amendments, but we'll go with questions. So any questions from council? So there's a question, we have Councilmember Lynn remotely. Her link is saying it's no longer accepting responses. What usually happens is that you're gonna have to refresh when it's time to vote. So we'll give you the go ahead, Kateri, I've been through this for several years. Don't panic. You gotta wait for it to refresh. So, the first part is we're gonna appoint the Broomfield Housing Authority. I'd like to thank everyone who took the time to apply and interview. The fact that we have so many interested and qualified residents is what makes Broomfield such a great place to live. If you applied and you're not selected, I encourage you to apply for other opportunities that will be available in January 2022 for appointments in March of 2022. For this evening, the procedures regarding the election process to fill the positions on boards and commissions are set forth in section 6.1 of Council's Procedures and Rules of Order, and will follow the process as outlined in the staff report. Before we proceed with appointments, Council has historically nominated the entire slate of applicants at the beginning. Would anyone on Council like to make those nominations? Mayor Pro Tem.
Thank you, Mayor. I would nominate all the applicants for the Broomfield Housing Authority.
Wonderful. We don't need a second. So the appointments we're considering are 5 total. We're going to first vote 3 members for 4-year terms and 2 members for 2-year terms. I just kind of said that twice. We'll begin with the appointment of 3 members to serve 4-year terms on the Broomfield Housing Authority. We're going to try it. Is it okay for them to get on the link now, Ms. Abeda?
Yes.
And I thought. Now, just as an FYI, I am not voting because we're not convened as the housing authority. I'm acting as the mayor right now, and I don't get to vote unless there's a tie. Clarification there. Now, if I was the housing authority, I could vote because I was the chair and a member of the authority, but that's not the case. Anybody? Y'all doing okay? It's the first time I've never gotten a vote. It's weird. I do, I need that puppy. Are you gonna display results? Because I haven't, no? We need music. I have some. Sing with you. Good as you. Yeah.
The voting is now closed.
And we do have 3 candidates who received the required votes over 6 or more, and that would be Bob Monroe, Alan Feinstein, and Nicholas Rosenbeck.
All right. Is there a motion?
So moved.
No, it has to be a little more specific. I'm gonna go with the mayor pro tem. We rehearsed it.
I'm gonna have to go back on this one, but I think I'm just gonna motion that those 3 members that were just mentioned be appointed to the Housing Authority.
Something like that. I'll go with Councilmember Shaft.
Thank you, Mayor. I move that, let's see, Bob Monroe, Alan Feinstein, and Nicholas Rosenbach be appointed to the Housing Authority Board of the City and County of Broomfield for 4-year terms lasting until March 31st, 2026, or until a successor is appointed.
Is there a second?
Second.
I didn't catch you because I guess it comes Member Leslie. All right, is there any discussion? Will the clerk please call the roll?
Jezerski,
Yes.
Leslie,
Yes.
Lamb,
Yes.
Lindstedt,
Yes.
Marsh Holston,
Yes.
Shaft,
Yes.
Ward,
Yes.
Anderson,
Yes.
Cohen,
Yes.
Hinkle.
Yes.
Well, that passes unanimously. The appointments next are for 2 members to serve 2-year terms on the Broomfield Housing Authority.
Okay, go ahead and refresh your link for the 2-year term. And the voting is closed.
And we did receive 2 candidates who received the requisite number of votes, and that's Joy Castillo and Linda Farbunch. Sorry, I slaughtered that name.
Farrenbrook. Thank you. All right, is there a motion? Mayor Pro Tem.
Thank you, Mayor. I think I got it this time. But kudos to Councilmember Shaft to pick up the slack. Anyways, I do move that Joy Castillo and Linda Farrenbrook be appointed to the Broomfield Housing Authority for 2-year terms expiring March 31st, 2024, or until a successor is appointed.
Thank you. Is there a second? Councilmember Marshall Olson?
Second.
Thank you. Is there any discussion? Okay, will the clerk please call the roll?
Leslie,
Yes.
Lamb,
Yes.
Lindstedt,
Yes.
Marsh Holston,
Yes.
Shaft,
Yes.
Ward,
Yes.
Anderson,
Yes.
Cohen,
Yes.
Hinkle,
Yes.
Jezerski.
Yes.
Well, that passes unanimously. Congratulations to those appointed, and we appreciate everyone who applied. The second part of the agenda item, meeting council's review this evening, is outlined in the staff report, is proposed resolution number 2021-195. Will the clerk please read proposed resolution number 2021-195 by title?
Resolution number 2021-195, decommissioning the Housing Advisory Committee.
Thank you. Is there a motion, Councilmember Leslie?
I move the motion.
Thank you. Is there a second? Councilmember Shaft?
Second.
Is there any discussion? All right, will the clerk please call the roll?
Lamb,
Yes.
Lindstedt,
Yes.
Marsh Holston,
Yes.
Shaft,
Yes.
Ward,
Yes.
Anderson,
Yes.
Cohen,
Yes.
Hinkle,
Yes.
Jezerski,
Yes.
Leslie.
Yes.
Thank you. That passes unanimously. All right, thanks everyone. That went well. Now get ready for the Mayor Pro Tem show. Next is council with self-appointments to various organizations and committees. Mayor Pro Tem Jezerski will help facilitate this portion of the agenda this evening, and I'll go get a cookie. Mayor Pro Tem.
Thank you, Mayor. Take your time. This is going to take a while. The show will go on. So, anyways, every 2 years following a municipal election, the city council appoints fellow elected officials to serve as representatives to various internal and external committees, boards, and organizations. Council does have a copy of the staff report, which includes a list of the appointments to be made and background information for each organization or committee. For this evening, the procedures regarding the election process to fill the positions on boards and commissions are set forth in section 6.1 of council's procedures and rules of order. In accordance with these procedures, the process tonight will be as follows. First, nominees will be identified for each position. If the number of nominees does not exceed the number of vacancies, council will proceed directly with the motion set point. For some reason, the number of nominees exceeds the number of vacancies, council will proceed to a vote using the electronic voting system that we just utilized. The results of each round will be electronically presented. Following completion of the electronic balloting, a motion to appoint candidates by name will be necessary. I will ask Danae Billiard if she has any additional information she would like to provide.
Thank you, Mayor Pro Tem. We just had a perfect practice round, so if we can repeat that, we will be set. We won't have nominations. What we're going to do is just have a motion to approve the entire slate that Council Mayor Pro Tem Jaworski shared earlier today. So Jake, if you can go to slide 4, please. We have it up here by council member. I do have printouts because I realize it's a lot to see, so if you prefer it on paper, let me know. We also have it in alphabetical order by the committee and which council members have volunteered or stepped up to serve on those different ones. So Mayor Pro Tem Jaworski will walk us through it, but we did put the visual out so that you can see and verify that it is correct before we move to the motion.
Thank you, Danae. So we will now proceed with public comments. Is there anyone, and I don't think there is, who would like to be heard? Anyone actually in the public that would like to make comment on this agenda item? I don't see anyone in our audience. So if there's anyone that would like to be heard online, please press *3, state your first and last name and neighborhood for the record. I don't have that up. Is there anyone online? We have no one online. So questions and comments from city council members are next. Are there any questions? Seeing none, the next part's going to take a few minutes. We're going to have to actually go through each one of the, actually I'm going to read through each of the boards and commissions and state who's been nominated for each one of these spots. So based on the feedback, council has a self-identified for the following boards and commissions. I'm going to start with the advisory committee on environmental sustainability. There were 2 positions here, 1 member and 1 alternate. We have Councilmember Lim as the member and Councilmember Anderson as the alternate. This is going to be in alphabetical order too, so just so everyone knows. Arts, History, and Cultural Council, we have 1 position there as Councilmember Cohen, who is being nominated for that position. Then we have the Board of Equalization. There are 2 positions, 1 member and 1 alternate. We have myself, Mayor Pro Tem Jaworski as the member, and we have Councilmember Marsh Holsham as the alternate. We have the Boulder County Consortium of Cities, and we have 1 position there as Councilmember Sheff, who's being nominated as the member. We have the Broomfield Building Corporation Board of Directors. There are 3 positions, a mayor, 1 member, and 1 alternate. Of course, we have Mayor Castriota as the member, we have Councilmember Leslie as a member, and we have Councilmember Lindstedt as the alternate. We have the Broomfield County Transportation Forum. We have 2 positions there. We have Councilmember Ward as a member and Councilmember Sheff as a member. We have the Broomfield Chamber of Commerce Board of Directors. We have 2 positions there. We have Councilmember Henkel as the member and Councilmember Leslie as the alternate. The Broomfield Westminster Open Space Foundation, there are 3 positions. The mayor, 1 member, and 1 alternate. Today we just have Mayor Castriota as a member, and we have Mayor Pro Tem Jaworski as a member as well. As the Broomfield Workforce Investment Board, there's 1 position, and we have Councilmember Lim as a member for that one. The Colorado Counties for Climate Action, CC4A, there are 2 positions, 1 member and 1 alternate. We have Councilmember Anderson as the member, and Mayor Pro Tem Jaworski as the alternate. Colorado Counties Acting Together, CCAT. We have Councilmember Leslie as the member. We have Councilmember Henkel to be appointed to the Affordable Housing Committee. Councilmember Sheff on the Transportation Committee, and Councilmember Lim as the general alternate. We have the Colorado Municipal League. There's 1 position there. We have Councilmember Marsh Holsham as a member, and Councilmember Sheff, try to the alternate in that position. Also, I'll throw in there Councilmember Sheff as the alternate for that position. And if anyone wants to jump in too, let me know. So we have The Denver Regional Council of Governments, Dr. Keck, there's one position there, and also an alternate. We have Councilmember Lindstedt as the member, and Councilmember Ward as the alternate. We have the Employee Medical Care Expense Plan Board of Trustees. We have one position, and that is Councilmember Lim. We have the Flatiron Improvement District, and there's one position there, and that is Councilmember Ward. The Jefferson Parkway Highway Authority Board of Directors. We're going to appoint one position for that. It's going to exercise both of those, two votes. It's going to be Councilmember Sheff. We have the Local Licensing Authority. We have 3 positions that are open, 2 members as one alternate. Tonight we'll just have 2 members. It's going to be Councilmember Cohen as a general member and Councilmember Marsh Holshin as a member. We have the Metro Area County Commissioners. There are 2 positions there. We have Councilmember Henkel and Councilmember Marsh Holshin. We have the Metro Mayor's Caucus. That will be the mayor. Go figure. Mayor Castriata. We have the Mile High Flood District. That will be also the Mayor Castriata. We have the North Area Transportation Alliance. And for this one, we will have 1 member and 1 alternate be appointed. And right now it's Mayor Castriata, and the alternate will be Councilmember Ward. The Northwest Mayors and Commissions Coalition, we will have 1 member being appointed and an alternate. And the member is Mayor Castriata, and Councilmember Sheff will be the alternate. We have the Northwest Parkway Public Highway Authority Board of Directors. And we have 1 position, and that's the Mayor Castriata.
And also the secretary.
And also should also be the secretary. Not sure if we're making that an appointment or not, but FYI. So we have 1 vote, 1 Broomfield. That will be Mayor Castriata and Councilmember Sheff. And you want any input as to who's the secretary or? No. Open Space and Trails Advisory Committee. There are 2 positions. The main general position will be Mayor Pro Tem Jezierski, and Councilmember Cohen will be the alternate. It says alternative here. Not sure why. Parks Rec, there's probably a joke there, but I don't have it. Parks Recreation and Senior Services Advisory Committee. The main will be Councilmember Cohen, and Councilmember Marsh Holshin will be the alternate. Pension Committee, we have 1 position, and that is Councilmember Lindstedt, generously volunteered for that. We have the Rocky Flats Stewardship Council. We have the Rocky Mountain Metropolitan Airport Youth Roundtable. 2 positions there, 1 member and 1 alternate. Councilmember Sheff is going to be the member, and we have Councilmember Walker as the alternate. The Rural Workforce Construction Board, there's 1 position there. We have Councilmember Lim. State Highway 7 Coalition, 1 position, and that is going to be Councilmember Anderson as the nominee. The US 287 Bus Rapid Transit Coalition, 1 position, and that will be Councilmember Anderson. And finally, the US 36 Community Solutions, there's 1 position, and that is Councilmember Ward. Okay. Having said all that, is there a motion to approve the appointments as outlined? Okay, go ahead, I'm sorry.
There was 1 omission. I think it was just accidentally.
Yeah, one quick correction that I hate to even bring up, but I want to make sure we're not making some legal mistake here. On the Brookfield Transportation Forum, the Dr. Cog member is the chair and the alternate is the vice chair. And the vice chair was listed, and Councilmember Sheff stepped up to serve as listed as listed. And I just want to make sure I wasn't giving away my, I don't know, I want to make sure it was properly.
I think that's a good point. I think we did have that on one of the lists. So yes, I think we need to add that for the Broomfield County Transportation Forum. Councilmember Lindstedt is also a member and the chair of that.
I don't know where to do that, but I just wanted it to be correct before we approve it. So.
No, it's not on there. It needs to be on there.
Yeah, no, and that wasn't on the list, so it should have been on this one as well. So I agree. Okay, as amended, just mentioned there is a motion to approve the appointments. Yes, indeed. Councilmember Winstead.
All right, send me a motion. I move that the council members be appointed to the boards and commissions as previously outlined through November 2023, or until a successor is appointed.
Is there a second? Councilmember Ward. Second. Is there any discussion? Don't see any hands.
Oh, yeah.
Oh,
Great job. All of you. It's really such a nice seamless process with, not have to get on the line and do the voting. So thank you all for collaborating and making this so smooth.
Thank you, Mayor. And I thought Councilmember Cohen had a question, but he's just straightening his hair.
Just want to tell that looked at you.
Will the clerk please call the roll?
Lindstedt,
Yes.
Marsh Holston,
Yes.
Shat,
Yes.
Ward,
Yes.
Anderson,
Yes.
Cohen,
Yes.
Hinkle,
Yes.
Jaworski.
Yes.
Leslie,
Yes.
Limb.
Yes.
Thank you. I believe those appointments are unanimous. Congratulations, everybody. You are officially on those boards.
You're officially going to be busy. Now,
Mayor, one other quick note, it was that the motion that was approved here tonight covers all the recorded appointments except the E-470 Public Highway Authority Board of Directors. Staff notified Council earlier today that staff will cover the E-470 Public Highway Authority Board of Directors in the interim.
City Manager Hodges?
Yes, thank you, Mayor and Mayor Pro Tem. So what we're recommending is we've been in touch with the Highway Authority and their advising attorney. They are not open to adjusting the bylaws that require an elected official. However, through our communications, I said, so if we did a summary of the minutes, and then reviewed the upcoming agendas, we would then supply any comments, questions, adjustments, and they were on board with that. So that would be our recommendation moving forward.
Awesome. Okay. Thanks for taking care of that.
You may have someone who is interested in this position.
Oh.
Over here, the question was this week for staff is what is the time commitment for that position?
Well, Councilmember Anderson can speak to it. I do, Councilmember Anderson.
So there is one meeting a month that lasts about, it can be anywhere from an hour to 3 hours. It usually ends, we're a non-voting member. So for preparation and then part of that meeting, a lot of times it's just an hour to 2 hours once a month. And then there is the option, they appreciate joining a committee, a roadway committee. And that would be another 1 hour a month. And the meetings are at the E-470 headquarters. It's, I can't give a name. It's a little bit of a drive over there, but amazingly well run meetings.
So I think that the question, Councilmember Marsh Holden, to help in your deliberations is the value add from Brookfield. Excuse me. And so being a non-voting matter, I don't know if over the last decade we influenced, informed, navigated, negotiated, or modified any of their path. It is a well-run meeting. Tim Schaefer is he's the executive director and a really stand-up guy. But again, from Brookfield's perspective, I would weigh that in your decision making.
Okay. Is there anyone that'd be interested in any of the other boards that hasn't been appointed to? We had some openings, just throwing that out there.
Do you want to clarify the openings? Like what are we short on?
You know, there's nothing that we were short on. I believe there were some of the non-mandatory ones, some of the internal ones that didn't have, or I guess you didn't have any appointments or had room for additional appointments. And I don't have that list in front of me offhand. I can think there was no one on the library board, I believe. I think that was open. That's one that struck me. I'm not sure if there was anything else that's, and they may have more information.
Yeah, we could pull it up if you would like. It was just all the random ones that were optional. Most of them are filled. So just wanted to make sure council had the opportunity. I think I know Councilmember Lim, for example, selected the workforce board, which wasn't required. So just making sure that council members knew we needed to fill the required ones, but if anybody wanted to do the optional ones, we would want to do those appointments this evening as well. But I think Mayor Pro Tem was able to coordinate that in advance. So hopefully we're
We're set. We've covered where we need to be.
Yes, we are. All right, well, seeing none, I think we are completed with this agenda item. And back to you, Mayor.
Thank you, Mayor Pro Tem, and to all the colleagues that cooperated and created this very smooth process. You divided and conquered these additional responsibilities, and I appreciate you. That was in my script. The city and county attorney report is next. Ms. Rogers, do you have a report?
A very short one. She has gone for the evening, but I just wanted to publicly, on the record, recognize Ashlyn Balut, who has been our intern for the last semester from Legacy High School, and she was here tonight finishing up her internship hours. She did some great work for us on research of codes on prairie dogs, on the graffiti ordinance, and recently wrote a brief on a case that just got issued. So Ashlyn, I hope you're asleep. You're doing homework now, probably. Thank you for coming to the meeting, but thank you for the work. And to those other high school students or college students listening, we love interns at the city and county of Broomfield. So reach out if you're looking for an internship.
Thank you, Ms. Rogers. The city and county mayor's report is next. Ms. Hoffman, do you have a report?
I do not. Have a happy holiday.
Thank you. Thank you for all the treats. And then item 14A was reviewed and approved earlier under the consent agenda. This evening, staff, although I can move past that, don't need public comments on it. There's no business before the Broomfield Urban Renewal Authority or the Original Local Improvement District Board of Directors. And there are no special reports or requests for future action this evening. That concludes the items on this evening's agenda. Is there any other business to come before council? Councilmember Cohen.
I promise I'll be short, but I didn't want to do this at the beginning of the meeting to delay the agenda. I don't want to make it tit for tat, but I do feel it's important to call out misinformation regarding our opening speaker. Made reference to VAERS, which is the Vaccine Adverse Event Reporting System, in which he said there were 10,000 deaths caused by the vaccine. VAERS is the system the CDC uses to monitor vaccine health. So things that are reported there are not conclusionary. They're just reports of adverse actions that happen after someone took a vaccine at any time after they took a vaccine. So you could have had a vaccine and 2 weeks later had a heart attack that would get reported into this VAERS database for the CDC to investigate. So their disclaimer, and I'll just want to add this to the record. A report to VAERS does not mean that the vaccine caused an adverse event, only that the adverse event occurred sometime after vaccination. Disclaimer continues to say the reports may contain information that is incomplete, inaccurate, coincidental, or unverifiable. So unfortunately, do not count VAERS as a conclusionary report in terms of vaccine safety.
Thank you, Councilmember Cohen. Anyone else?
I want to second that.
All right. All right, then there being no further business, the council meeting